practitioners out there doing their job. That's why we're saying, because they are going to industries, they must work with the ministry, and we have made a provision, a new clause, to get them regulated so that even if they are doing their work, they are doing it in consultation with the Ministry of Gender. And another issue which has been, I think those are the areas they have touched. Yes, you talked about home workers. The law applies to every workplace. All labor laws apply to every workplace. Even if it is your maid who gets a problem, the laws cover them. They can approach any labor officer or government or anywhere. The laws apply to everybody.
Dr. Olme.
Yeah, thank you very much, Right Honorable Speaker. The chairperson of the committee, I wanted the attention of the chairperson of the committee, whether they looked into other workspaces where there are safety or even hazards at within the occupation spaces, such as the councils, district councils, sub-county councils, where we see fights, people hitting each other,
Parliament.
and going away with wounds. Parliament is one of these spaces.
Yes.
Yeah, while we are here in Parliament, who is responsible for us, for instance, if at all we get in trouble at work, within the councils, and so on, as the committee addressed itself on these spaces as well. Thank you.
If somebody is coming to work in most workplaces, then gets an accident, that person will be compensated under the workman's compensation. Those people are provided for. And I'm sure even at Parliament, if we got an injured here, we are supposed to be taken care of. But Honorable Ulume has widened the space to people who are fighting out there, fighting against each other. Those ones become criminal issues where you need to report to police.
Thank you. Oza?
Thank you very much, Right Honorable Speaker, for the opportunity. Thank you very much, Chair. Madam Speaker, West Nile has been invaded by illegal gold miners. Others are in Metal Hills, others in Terego, others in Yumbe. And more often than not, these people do not follow occupational safety rules. No helmets, no gloves. They enter into tunnels where there's a lot of heat. And when they come out, they become sick. Still, they are not being catered for. So all this will be put into consideration. Thank you very much.
Are those people employed to do that, or they go willingly?
Right on the speaker, they are illegal. They are illegal. Those are illegal gold miners.
If they are illegal, then honorable members, we need to move. Yes.
Thank you. One clarification from Minister, and I'm happy she's coming up. Can the Minister clarify to us what exactly made it so difficult for them to operationalize the law that is in place, and give us comfort that the amendments that we're going to make will make it easy for her to operationalize the law that you're about to amend?
Lob. Honorable Minister, first word for Lob.
Honorable Speaker, I think we need to get commitment from the Minister. For over 10 years, there's been no regulations. We don't know why. And yet this is a critical requirement, because that's one way of showing that as government you are committed to implementing these laws. Can we get commitment? Because we are here, we think that this is a good law. There's even no minority. I was consulting my colleague, the Shadow Minister for Gender, and she told me in the committee they were moving in sync, because these are matters that are for the good of everybody. So now that we are committed to bettering this law, can we get commitment from the Minister that as soon as, I don't know, you will commit to us, the regulations get to come? Thank you.
Thank you. Thank you. Honorable Minister. Hey, that was Mobende.
Honorable Speaker, I think we need to get commitment from the Minister. For over 10 years, there's been no regulations. We don't know why. And yet this is a critical requirement, because that's one way of showing that as government you are committed to implementing these laws. Can we get commitment from the Minister that as Thank you very much, Right Honourable Speaker, for the opportunity. I want to appreciate the committee for the report. But my concern, Right Honourable Speaker, as we plan to set a board that is going to cater for the operational safety and health at the top, we should also think about having these health and safety officers in the various workplaces. If we don't do that, then compliance will be very hard to all these that we are doing.
True.
Thank you.
Thank you.
Thank you, Right Honourable Speaker. Colleagues, I will first answer the question about the challenges of the operationalization of the law. Colleagues, the law was focusing on the workplace with more than 20 workers only. The amendment to this makes the law apply for all workplaces. And the trainings are catered for under the law in section 13 of the old law. The issue of the board, Right Honourable Speaker, colleagues, we know very well that apart from before the rationalization, there are also those other boards that were supposed to take place to be established. But this particular one, Right Honourable Speaker, we did not have the money to operationalize the board. And the advisory is not standing board. So due to financial implications, we have not been able to have the board in place. The member asked about the question, the person who suffers from the injustice at the Workers' Compensation Act addresses this issue. The OSH is still centralized, especially for those who are asking about the district, why it's not decentralized to the district. The OSH is still decentralized, hence we are using this at the district. At the moment, we are using our labor officers to handle most of the disputes affecting the staff of the local government. And also industry staff still apportion them to work with the labor officers at the district level. There was a question about the inspectors. We have limited numbers, that is true. Your Excellency, Right Honourable Speaker, the issue of the wage we know very well. We are not in position to have this, but if we are given the opportunity, we'll be able to have as many inspectors as possible. But we are able to work with the ones we are having so far, who are in the major industrial regions.
Right Honourable. Right Honourable. The issue of the regulation, Honourable Minister, the law wanted a commitment on the issue of the regulation that if we pass the law today, how fast can we have the regulation? Since in the last 10 years, we've not had a regulation.
Right Honourable Speaker, we commit that we shall have the regulation in place at least within the 1 year.
10 years, 1 year.
Do we have something we are trying to chew, Attorney General? Do we have something we are trying to chew in this law?
Right Honourable Speaker, on the issue of regulations, I fear that we are jumping the gun, but when it comes to discussing clause 118, on which our two sides have not agreed, our proposal was, among others, that a proposal for regulations can be sent to the sectoral committee to sieve it and make adjustments before it is passed. And that may require a particular time. So I was thinking that that particular area be discussed when we get to looking at clause 118 of the bill.
No. You know, Honourable Doug.
Incidentally, it is 118. Yes.
Doug.
Yes.
What we are saying, when we pass this law, do we expect regulations as soon as possible? Because it has been there.
Right Honourable Speaker, I do not want to commit on behalf of my colleague, but this is what I can say because the Honourable Minister would have to work with the Attorney General's chambers. We should have this done at most within 4 months.
What does clause 118 say?
118 talks about the minister establishing regulations and whether he's required to table them in Parliament for approval or not.
Clause 118 of which law? This one?
Yes, the occupational safety.
We have not seen a clause 118. In the Parent Act, unless if you're talking
I'm
about
looking
the
at
parent.
the bill, 118 of the bill, which is 119 of the Act. The numbering changed. 119 of the Act, which is 118 of the bill.
Honourable Minister, we will give you 3 months to have the law in place. Because if you have a defect, you have a problem that you need to solve. Immediately we pass the law, it is assented, you go and work on the regulations.
Much obliged, Right Honourable Speaker.
Thank you. Lopez is asking you, what have you committed to? That in how long you'll bring the regulation?
Right Honourable Speaker, we are committing that in 3 months we shall be having the regulation in place. Thank you.
Honourable members, if you agree with us, if we pass that regulation of on the legislative scrutiny, we are going to get members to make a follow-up on these regulations. And we'll even name the members tomorrow so that we now see. I put a question that the Occupational Safety and Health Amendment Bill 2023 be read for the second time. Those in favor say and the contrary nay. The ayes have it.
The Occupation Safety and Health Amendment Bill 2023, Bills Committee stage. Clause 1.
Chair.
Madam Chairperson, Clause 1 is amended. A, by inserting immediately after paragraph C the following. D, by inserting the following new definitions in the appropriate alphabetical order.
Can we come back to that after, in case on interpretation?
Okay.
We stand over clause 1 on interpretation.
Clause 2.
Clause 2, there is no amendment. I put a question.
Madam Chair, on this clause 2, which seeks to amend section 9, it reads that an inspector may, in consultation with the Director of Public Prosecution, prosecute, as the case may be, before a court any charge, information, complaint, or other proceedings arising under this act or in the discharge of his or her duty. My question with this is the minister should clarify what is the intention. Is the intention that before the inspector prosecutes must get permission from the DPP? What are they trying to cure here? Because this is about the prosecution powers. And then two, in the Mother Act, these powers were limited to prosecute before a magistrate's court. And then under clause 2, it was also provided that you could not challenge when a charge is brought at the instance of the inspector, you would not charge. So why are you doing away with that provision and now making it wide for the inspector first to now go to any other court, removing the limitation around the magistrate's court? But also the wordings here appear that this provision of the DPP can be dispensed with, because he's saying the inspector may in consultation. So it leaves that discretion to the inspector.
There, we have not gotten exactly what he was mentioning. Maybe he can repeat again.
Attorney General, did you understand? Where the law says that before the inspector prosecutes, he must get permission from the DPP. But then the question is, what qualification is the inspector? Does he have the powers to prosecute? I mean, yes, to prosecute. And how do you go and get the powers from DPP for you to be able? Because now when you read in the Parent Act, Section 3, who is an inspector, the appointment of inspectors, subject to any written law relating to the appointments of a person to the specific service, there shall be appointed commissioner and any other inspectors as may be necessary for the purpose of this act. So an inspector will be appointed for the purpose of this act. However, you're saying in the Parent Act, put Section 2, in the bill, powers of an inspector to prosecute.
Chair, under the Principal Act, Section 9, the inspectors have been given powers to prosecute. And under subsection 1, an inspector may prosecute or conduct, as the case may be, before a magistrate's court, any charge, information, complaint, or other proceedings arising under this act or in the discharge of his or her duty. And then under subsection 2, it says where prosecution is brought at the instance of an inspector or prosecution is conducted by an inspector, an objection to the competency of the inspector to give evidence as a witness in the prosecution shall not be sustained. Now, these two provisions are being dealt away with. They are replacing it with a new, as proposed in the bill under clause 9. But what they are introducing first is that they seem to be interested in giving the DPP a role which was not under the previous. But the way it is worded here, it does not cure that, because he's saying the inspector may in consultation, meaning there is no obligation to go to the DPP. I have a feeling that they wanted to cure that, because when criminal proceedings under the law, under Article 120, you know what the DPP does. It appears as if the intention was to bring the DPP, to take away the powers that may have been abused by the inspectors, so that the DPP has a role in the prosecution. But the way it is worded here means that the inspector can still actually prosecute without the DPP. That's the issue I wanted to raise first. Then secondly, is that in the Principal Act, the powers to the inspector was limited to prosecution in the magistrate's court. Now, when you do away with that, it's now you have given the inspector powers to prosecute in any court, including the court martial, by the way, if I may tell you. Yeah. So is the intention that now the inspector can actually charge me. Yeah. No, it's still a court, I believe. Is the intention now that when I've not managed my workplace very well and I've breached certain provision, the inspector can actually now say, I'm going to charge you in the court martial.
Madam Chair, if I have understood Honorable Dur well, in the first instance, the proviso intends to let the inspector consult with the DPP because at any one time, you do not know the degree of the offense that arises. Some breaches may require the consent of the DPP. You know that there are offenses that cannot be tried without the consent of the DPP. So if you completely lock out the DPP and say that the inspector will prosecute without consulting the DPP, there will be a contradiction. I'm just stating my understanding of this. Now, the other one, permitting prosecution in any other court also goes to say that there are some offenses because courts have jurisdiction. There may be offenses that may not be triable in a particular court in which the inspector has jurisdiction and can only do so in a higher court with jurisdiction. But let's not mix that with the court martial because the Supreme Court has made a declaration to that.
You know, here it was only limiting to magistrates' court. It was limiting to magistrates' court. Yes, Counsel? Sorry, Honorable Minister.
Right, Honorable Speaker, even Counsel is actually, that is an earned reference. I'm trying to get to be, I'm a Counsel actually, yeah. But just to support the Attorney General, I wondered what Honorable Odur wants. The law, if it is drafted in such a way that gives latitude, the word may, unless you think that that discretion will be abused, which you could state it. But a word may, in consultation, what would be the role of the DPP? Would it be the one to sanction? You give the prosecutor, the inspector, the opportunity to determine, as what the Attorney General said, to determine the fora, the jurisdiction, the offenses, and also, Honorable Oduri, is there would be no any circumstance that inspector envisaged in this bill would have reference to the court's martial, because the offenses under court's martial are prescribed and they are not relating to workplace offenses.
Honorable members. Honorable members, the justification that has been given, you've had the justification. Honorable Duru, are you satisfied? At least one thing you're sure that it will not be court-martial, but it will be a competent court? And we are trying not to limit really to magistrates' court because of the gravity of the matter may be higher than what magistrates' court may handle.
Chair, one of the observations by the justices of the Supreme Court is that when we come here, instead of clarifying certain situations, we leave it to be open. And in that judgment, court-martial has been recognized as a court. It is the jurisdiction that is in question. They didn't say it is not. So when you leave the word court here, and court-martial is a court, it can, and I wanted that to be on the record. Secondly, if the Attorney General could actually tell us which offenses
assuming
are
we
here.
say a competent court. Because that would depend on the what? You just put a competent court. Before a competent court.
Chair, I didn't want to go into that argument because that court also in some cases. But the point I wanted to raise is that if the intention here, for me, if you read carefully Article 120, my thinking and my interpretation is that no criminal proceedings, including even those ones in the court martial, can actually be started without the DPP. So here, if the intention is that you want to involve the DPP, the word may, I am uncomfortable with that. Because the DPP is the public guarantor of abuse by the executive. The DPP, that's the role. The Directorate of Public Prosecution was put there and said so you shall be independent so that in case the executive has some excess and wants to abuse, the DPP is supposed to guarantee that by saying stop, don't charge or charge, something like that.
Do you have an issue with the shall?
Right, Honorable. I like the eloquence of my colleague, but allow me to say this. If you read the OSH, the bill as it is intended to create a mechanism to oversee and enforce safety within the health system. In essence, it's creating a kind of pseudo-disciplinary committee. I do not want to be quoted on those particular words, but I'm just using, figuratively speaking, a court within a health system, okay? Meaning that there are certain things that can be handled within that system, within that health setup, without necessarily referring them to the DPP. That's why they are saying they are those that may be exaggerated and may require the consent or consultation with the DPP. That's why we should use may and not shall.
Thank you. Chair, this parliament has made pieces of legislation where we have given prosecutory powers to different individuals without even necessarily involving the DPP. We have done so, you know, under the Wildlife Act and other pieces of legislation. I'm not so sure, Learned Attorney General, what you want to achieve here. I'm not so sure. Either you give full prosecutory powers to inspectors, the way we've done with other pieces of legislation, or...
Honorable, let's not go generic. Let's look at what is specific here. You read what the law is saying.
Yes.
And no, you read it so that we...
Right, Honourable Speaker.
Clause 2.
The clause 2 says, powers of the inspector to prosecute. An inspector may, in consultation with the Director of Public Prosecutions, prosecute as the case may be before a court any charge, information, complaint, or other proceeding. And right, Honourable Speaker,
arising under the Act,
yes,
or in discharge
of his or her duty. Yes.
As the case may be.
And right, Honourable Speaker, Chair, what I am asking the Attorney General to clarify and help is what we want to achieve here. Because this House has set a precedent. We either give full prosecutory powers to inspectors or require that they cannot prosecute before consultation with the DPP. Because this is neither here nor there. And that's the problem. So you just clarify what do we want to achieve? Because this provision here can be problematic. In fact, the discretion you are talking about is one which is subject to abuse. On what basis, for example, will the inspector use to consult the DPP? What would be the basis that now in this particular case, let me consult the DPP. Yeah. In this one, let me not consult the DPP. That's why we must be very clear. Either we give them full prosecutory powers, or the way we've done with the other pieces of legislation, require that DPP sanctions or consults. And we move.
Yes.
Right Honourable Speaker, I do not like insisting on matters a lot, but on this one, Right Honourable Speaker, I'm calling upon my colleagues to understand my position. We cannot anticipate the kind of offences to be committed. For purposes of clarity, we can have certain aspects put in the regulations. Certain perimeters can be put in the regulations. Let me give you an example. Let me use an example, a hypothetical one. A doctor who deliberately kills patients. Yes, and injects them. I'm giving an example. Are you going to say you leave that to the inspector to prosecute? It does not require the DPP. So that's why we are saying, no, the offenses are light and heavy based on a particular case. That's why we should allow the regulations to stipulate which kind of offenses will require the DPP and which kind of offenses can be prosecuted.
Honorable Attorney General. Honorable Attorney General. They said an inspector may, in a consultation with the Director of Public Prosecution, prosecute as the case may be. As the case may be. That is still discretionary. Even if we put shall, it will still remain as the case may be. What is hard? Don't we have trust in our DPP? Yes, Council.
Right, Honorable Chair. I think with the text being projected up, there are key issues there. The inspector, and then the provision for consultation with the DPP. And we all know the constitutional role of the DPP in relation to criminal prosecution. And then, as the case may be, as the case may be also offers that, that's as case-by-case basis. Yes. It's not that the inspector will consult in all matters. Yes. And at all times. This is my understanding. And looking at that the provision as proposed there, I think it would be good that I had provoked Jonathan, Council Honorable. He's also a bus owner. He runs to tell us what would be the subject of his concern with the use of may. But in all fairness, this is a better way to frame that, because you get an inspector, you don't want that inspector to overstep the mandate to prosecute on criminal matters. You don't want a prosecutor to overstep the mandate in criminal prosecution.
You will start cherry picking on what he thinks he should consult.
And unless this House feels that is not good, then you use the word shall. But exactly. If it's fair, you use may.
Yes, workers. Let me first hear from workers. Chair University.
Thanks very much, Madam Chair. I listened to my colleague and the Attorney General, but I want to give you a background, and that's why I'm coming in for shall. I had stated in coming in for this. When it comes to the regulations which they are referring to that they are bringing very soon. Experience has shown us, including NSSF, Minister of Gender has never brought regulations. Let us tie it now and finalize it.
We are not in a market. What is your position, Chair?
Madam Chair, when we were interacting with the movers of the bill, the reason they brought this out is that on a number of occasions they have failed to win those cases because sometimes they are wrongly presented to the courts. That's why they now decided to amend to bring in so that they are able to consult with the DPP so that the cases.
So we must. Yeah.
So I agree we can go with shall.
Thank you.
Madam Chair, that now is more clear, and I would now propose that instead of the use consultation, we say consent, because that's what they do, consent of the DPP, not consultation, to cure what they are saying. Yes.
Chair.
Madam Chair, consent will almost stand the whole meeting. There are cases where, for example, provision of drinking water at a workplace is a simple issue which the inspector can handle. But there are those grave cases like where you are negligent, employer is negligent, and the people are crushed by the machine. So they are different. So when you say consent, it means every time the inspector must seek for the consent. So I think shall would be okay.
Consultation. Let's see.
Right, Honourable Speaker.
Asman, why are you making noise?
It looks like I'm defeated on this. I will begrudgingly concede to shall.
Shall, yes.
I will begrudgingly concede to shall and consent.
And what?
And consent.
Okay. AG. I put a question that clause 2 be amended as proposed by Honorable Oduro and further amended by Honorable Deputy AG. Those in favor say on the contrary, nay. The ayes have it.
Clause 2 as amended.
I put a question that clause 2 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it. Ekanya, you have crossed.
New clause.
New clause.
Insertion of a new clause after clause 2. The bill is amended by inserting immediately after clause 2 the following new clauses. Amendment of Section 10 of the Principal Act. Section 10 of the Principal Act is amended by deleting subsection 3. Insertion of Section 10A in the Principal Act. The Principal Act is amended by inserting immediately after Section 10 the following. 10A, functions of the board. The functions of the board are A, to advise the minister on matters concerning occupational safety and health. B, to advise the minister on formulation and implementation of policies, plans, programs in occupational safety and health. C, to set standards, guidelines of practice for safety and health practitioners. And D, to perform any other function as may be necessary for the purposes of this act. Justification. Section 10.3 has been incorporated under the proposed Section 10A, which provides for the functions of the board to standardize and regulate the work of safety and health practitioners.
Minister.
Right Honourable Speaker, I take note of and concede with new amendments proposed after clause 2 to stipulate functions of the OSH board to include regulations of the safety and health practitioners.
AG.
I concede.
I put a question that the proposed new clause stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 3.
There is no amendment. You have an amendment on 3?
Yes. Right Honourable Speaker, clause 3. The bill seeks to repeal the word as far as reasonably practical. And I don't see its danger. If I may read, the parent law 13, it is the responsibility of the employer, A, to take as far as is reasonably practicable all measures for the protection of his employees or her workers and the general public from the dangerous aspects of the employer's understanding. I don't see the danger of this as far as reasonably practical. I don't see its danger. Because you take measures as far as it's reasonably practical.
But we don't want compromise on hazards. We don't really.
Because the way it stands now in the law, it gives latitude to the courts to determine what is practical in the circumstance and what is not practicable. But when we remove it, even what might not have been foreseen, every other circumstance would be blamed onto the employer. For me, I really don't see a problem with it the way it stands.
The employer must ensure safety. Must ensure safety. For instance, if you're in a petrol station and there is fuel that has spilled over, and you say, that's not my responsibility, and yet that can cause a problem. So you must ensure that there is safety here. You get it, eh? No, that's right.
Maybe, Chair, you would hear from the Attorney General. Do we presuppose that the employer should have been a demigod that must see everything? Because there are situations that might not be foreseen.
Right,
hazards, Honorable Aisha, hazards.
Right, Honorable Speaker, the reason they are removing the word reasonable, practicable, is to create strict liability on the employer.
Yes.
Because the word reasonably practicable gives you leeway to say, I could not afford or I could not manage. So they are squeezing you, no excuse. Yes.
I put a question that clause 3 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 4.
I put a question that clause 4 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
New clause.
New clause.
Madam Chairperson, insertion of a new clause after clause 4. The bill is amended by inserting immediately after clause 4 the following: amendment of section 15 of the Principal Act. Section 15 of the Principal Act is amended by substituting for the words safety representative. Wherever the words appear, the phrase safety and health representative. Justification to include an aspect of health in the reference to the representatives of safety and health at workplaces who are currently referred to as safety representatives.
AG.
I concede to this.
Minister.
Right, Honorable, we concede.
Thank you. I put a question that the proposed new clause stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 5.
Chair.
Clause 5 is amended. Amendment of Section 16 of the Principal Act. Clause 5 is amended A by inserting immediately before paragraph A the following. In the head note, by inserting immediately after the word safety, the words and health. B, in paragraph A, in the proposed subsection 1, by inserting immediately after the word safety, the words and health. C, by substituting for the paragraph B, the following. B, by substituting for section 2, the following. 2, the safety and health representative shall represent employees on the safety and health committee. D, by inserting immediately after paragraph B, the following. C, in subsection 3, by substituting the words safety committee, the words safety and health committee. Justification to include the aspect of health in reference to the committee of safety and health at workplaces, which is currently referred to as safety committee.
AG.
Insertion of the new clause after clause 5. The bill is amended by inserting immediately after clause 5 the following clauses. Insertion of section...
AG.
Right, Honorable, we are in agreement.
That's a consequential. Yes.
All right, Honorable, we concede.
I put a question that clause 5 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 5 as amended.
I put a question that clause 5 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
New clause.
New clause.
Madam Chairperson, insertion of clauses after clause 5. The bill is amended by inserting immediately after clause 5 the following clauses. Insertion of section 16A in the Principal Act. The Principal Act is amended by inserting immediately after section 16 the following. 16A, registration and licensing of safety and health practitioners. The minister shall make regulations to provide for the registration and licensing of safety and health practitioners. 2, a person shall not conduct a safety and health risk assessment, safety and health audit, or any other assessments or audit required under this act unless the person is registered and licensed by the commissioner as a safety and health practitioner in accordance with this act. 3, a person who contravenes subsection 2 commits an offense and is liable on conviction to a fine not exceeding 1,000 currency points or imprisonment for a term not exceeding 2 years or both.
Honorable Minister.
Honorable Speaker, I take note of and concede with the new amendment proposed on clause 5 to include the aspect of health in addition to the safety aspect.
Thank you. AJ.
We are in agreement, right, Honorable?
I put a question. Was this a continuation of that? The replacement. It's a new insertion.
Madam Chair, this is a continuation, replacement of Section 21 of the Principal Act. Section 21 of the Principal Act is substituted for the following. 21, measures to monitor health of workers. 1, an employer shall put in place measures for
Yes. Continue. Have you finished?
Shall put in place measures for A, monitoring the health of workers, B, management of workers exposed or likely to be exposed to occupational hazards, and C, prevention of occurrence of occupational diseases and disease outbreaks. 2, for the purpose of this subsection 1, an employer shall have the duty to A, prepare and submit to the Commissioner for approval a health surveillance plan for the employer's workplace. B, inform a worker of any health hazards involved in his or her work and the health arrangements that have been put in place to protect the worker. C, carry out pre-assignment medical examination on a worker where the assignment exposes the worker to danger. D, carry out medical examination upon termination of the assignment or employment of a worker where the assignment or employment exposed the worker to danger. E, carry out periodical medical examination on a worker based on findings from the medical examination of a worker on the recommendations of the Safety and Health Committee. And F, put in place occupational health services. 3, for avoidance of doubt, an employer shall bear the cost of the medical examinations required to be performed under this section. For purposes of this section, health surveillance plan means a plan put in place by the employer to monitor and assess the health of workers who may be exposed to hazards in the course of employment. Mental health services include assessment, diagnosis, treatment, care, counseling, or any intervention provided to the worker to promote emotional, psychological, and cognitive well-being of the worker. And occupational health services include disease outbreak management, wellness programs, rehabilitation of sick workers, mental health services, vaccination programs, promotional health services, and other services prescribed. Under this health surveillance plan, safety and health risk assessment report and any national health guidelines. Notification of occupational accident, disease, and incident. 1. An employer shall keep and maintain a record of an occupational accident, occupational diseases, outbreak, and incidents. 2. Where an occupational accident or occupational disease outbreak occurs, the employer shall notify the commissioner in a manner and within the time prescribed by regulations made under this Act. Justification: to ensure regulation of and standardization for safety and health practitioners. There is a need to carry out occupational safety, occupational health and surveillance of the risks arising at a workplace and put in place measures to safeguard the health and safety of workers. There is a rise in risk related to lifestyle at the workplace, for instance, long hours of sitting and mental illness. So there is a need to have occupational health services to monitor the health of workers, to ensure that the commissioner is able to access information on occupational diseases and occupational accident for action.
I would love to hear from Attorney General, but also the Chair and the Minister. What measures, what sanctions do we have prescribed in this amendment to cater for those employers who do not comply with these enlisted demands? Are they strong enough? If they are there within, maybe you recite them so that we're able to know that they can stand and help us to make sure that people do what they are supposed to do. For instance, I would be happy if somebody is not complying, we revoke their license if somebody is operating. What measures? What sanctions?
Check section 102. Yes. Yes, Chut.
I just wanted to propose an amendment on registration and licensing, saying by the commissioner. I would have proposed that it should have been the Occupational Health and Safety Board. Ideally, you cannot be licensed by an individual. There should be a body that is overseeing that practitioner. And we have the Occupational Health and Safety Board that is mentioned here. Secondly,
it should be a minister.
Yes, but in this act, there's the Occupational Health and Safety Board. And that is what I thought should handle, not the commissioner. If the board is not there, then it can be the minister. But in this case here, there's a Occupational Health and Safety Board. The second issue, I want to also propose another amendment. We've provided that it will be the duty of the employer to inform the worker of the hazards at their workplace and the preventive measures to address them. However, this provision does not give a timeline, whether you're supposed to inform 1 month after employment, 2 months. So my proposal is that we should add a clause on it that this information should be provided within the prescribed time by the regulations, so that it is not just open-ended for the employer to inform at whatever time they wish to. Related to that also is medical examination after termination. There is no prescribed timeline. And I'm proposing again that we should put a clause within the period prescribed by the regulations. The standard practice actually is normally within 30 days, but you can have the period prescribed by the regulations. So I just wanted to propose those amendments within it.
AG?
Chair, before the AG comes, the chairperson presented two. One, the insertion of a new clause, which we have not processed, and the amendments coming like from the Honorable Pia Chut. I thought that issue should be dealt with standalone.
What we are looking at is the new clause.
Yes, but she also went ahead and also proposed an amendment purportedly under a new clause, but she's amending section 21. And that's why also some ideas have come from Achute. So maybe we first deal with the new clause before we go to the amendment, and the record should correct that that's not a new insertion as they had proposed. If they intend to amend section 21, it should be reading amendment of section 21.
They're actually saying replacement of section 21 of the Principal Act.
Yes, which is an amendment. It can't be a new insertion.
So the other insertion, these are 2 in 1. Now, can we first split and first have the insertion, which was S16A, which you accepted already, and then we go to part B. I put a question that the proposed new clause stands part of the bill. Those in favor say the contrary. The ayes have it. Minister, 21. The replacement of 21.
Right Honorable, we concede with the amendments proposed after the clause 5 on the registration and licensing of the safety and health practitioners.
General, I'm requesting for purposes of clarity that Achuti repeats his concerns so as I see how it fits in here.
Yeah, I was on 2B and 2D. It is providing that the employer has to inform the worker of any health hazards involved in his or her work and the health arrangements that have been put in place to protect the worker. My issue is that there is no timeline provided. And so I was proposing that we would add a clause saying that within the prescribed times, within the times prescribed by the regulations, so that there's a time period. The same also applies to D, which talks about carrying out a medical.
Are we together there?
Yes, the second is also applying to, which is D, which is talking about medical examination after termination. And what we're trying to propose, it also doesn't give a timeline. So we're saying we also indicate that within the period prescribed by the regulations, so that after termination, there's a maximum period within which that medical examination should be done. Chair, we had jumped over what I had proposed, the registration and licensing by the commissioner. I thought we needed to discuss that, whether it should be the commissioner, the minister, or the board. Thank you.
Yes.
In response to what Honorable Achuti is proposing, my view would be that we simply say before commencement of the job, before you do the work, you should be told what to expect. So instead of referring again to regulations which may not come, because these days I don't trust most of the ministers when it comes to regulations. Maybe the minister here is good, but some ministers are suspicious.
Thank you. You see, sometimes legislation is not impregnated with many issues. And the reason why Parliament empowers ministers to make subsidiary legislation is to cater for some of these exigencies. And you would do us a lot of good if you really took the wise counsel to have regulations in place. The reason why, for example, the Honorable Chota and others are concerned about this, ideally, matters to do with timelines are issues that can be adequately covered in regulations. But because we don't have a culture as a front bench of having regulations, it creates a very big problem. Now, this particular issue, for example, will keep changing. Circumstances and situations at workplaces keep changing. That legislating on time, for example, on this matter, which is a duty, the way it is worded becomes extremely difficult. So I think, Minister, if you really made a commitment on the issue of regulations, these are matters that can be effectively and comprehensively covered under regulations because they are circumstantial. The way this clause is worded is creating a duty on the employer, an obligation on the employer. So even it also follows that when it comes to certain timelines, circumstances may change, where you may require that flexibility is exercised through regulations.
Chair.
But Chair,
Yes.
I'm worried for one thing. If we refer to regulations, somebody is employing somebody, and the minister has not made regulations, and we are referring to regulations which are non-existent.
Non-existent.
Do you see the gap? It is so huge, and we can't speak about it. So, right about Speaker and Chair, the best thing we can do is to ask that you, the employer, you do your part before the person starts with employment. Before the person starts their work, tell them what to expect. Then it will be easy. For me, I would think that is rather direct. And the Attorney General, being a good drafter, can draft a good piece to fit that particular requirement.
Right, Honorable Chair, what Honorable Silos is saying is a bit not very practical because circumstances keep on changing. Suppose a new machinery is bought, there are new hazards that come in. So we cannot simply make it a duty before commencement of job because new circumstances will arise during the employment time that might need the employer to update the employees on the hazards at the workplace. So I agree with Honorable Basarira that the regulations will take care of that. The regulations would explain how often and under what circumstances would the employer keep updating his staff of the new hazards that would be at the workplace.
You know, when you look at clause 21 on the Parent Act, look at clause 21 on the Parent Act. Section 21, employer to supervise the health of workers. It talks about the pre-assignment medical examination of workers before assignment of specific tasks, which may involve danger to their health or that of others, then periodic medical examination of workers during employment, then the biological monitoring or investigation which may be necessary to control the degree of exposure and supervise the state of health of workers. I don't see why it is even being replaced. Why are we replacing what was better? This was much better.
Right, Honorable. I do not think this is entirely replacing the old section. It is an amendment.
Read the heading. Replacement of section 21 of the Principal Act.
Yes, and I think some time back you realized that this was a mistake. The word replacement was a mistake. It should have been amendment of section 21. Not replacement.
Section 21 of the Principal Act is substituted by the following. Substituted. That's what the committee is saying, Honorable Doug. So, can we have this corrected? Is it a substitution, a replacement, or an amendment?
Right, Honorable. My understanding of this is an amendment.
Chair, explain.
Madam Chairperson, as a committee, we expanded on section 21. That's why we said we are replacing it because we expanded and gave more obligations to the employers in protecting the health of workers.
So you're substituting what was in the Parent Act, or you're amending it? I want it on record. Yes, no.
Right Honorable, I think the intention is to expand the obligations of the employer in this case. So maybe the draftsperson would help us. This is not a replacement, it is an amendment. It's an addition to what exists in the parent law. We are simply heaping more responsibility
So what has
on
been
the employer.
Chair, just tell me what you've added on what was existing and where. Is it after subsection 1, 2, or whichever? First tell me what you've added.
Madam Chairperson, we added for the health surveillance plan, we replaced because we went up to 4. For purposes of this section, we even intended to interpret the words which have been used within this.
Which words? Chair, read for me.
Like under 4, health surveillance plan, these words are not used.
So you've added 4.
Yes.
On 21. Wait, let's sort out this. You've added 4 on 21.
Yes.
Okay. Let's add 4 here. Yes. Can we look at the Principal Act together with what is in the bill? The Principal Act, that is the employer to supervise health of workers. 1, subject to any conditions determined by the Commissioner, every employer shall provide for the supervision of the health of the workers exposed to or liable to be exposed to occupational hazards due to pollution and other harmful agents in working environment. And this duty shall include A, pre-assignment medical examination of workers before assignment of specific tasks which may involve danger to their health or that of other workers. B, periodic medical examination of workers during employment which involve exposure to a particular hazard to health. C, biological monitoring or investigation which may be necessary to control the degree of exposure to supervise the state of health of workers concerned. D, regular medical examination for biological or other tests or investigation after termination of assignment which may cause or contribute to the future health impairment. 2, in any case, as may be prescribed by the Commissioner, any employer shall make adequate arrangements to provide occupational health service in undertaking to secure adequate health for workers and for other persons in the area under the influence of the undertaking. 3, it shall be the duty of the employer to inform the workers concerned of any health hazards involved in his or her work. That is 21. So where are we, which one are we adding? So on these first three, are we together with what you've
Chair, what the committee did, which in my opinion is a good job, they did a redraft of the provisions of Section 21 for clarity. But they have also added some other provisions in line with other clauses we have already passed or we are also going to pass. For example, the requirement to file with the commissioner a surveillance plan, a health plan, something like that. So this is a replacement which is in a better shape, but they have added certain things to it. So if you compare the 21 they are replacing and the 21 in the law, this is much better because it's wide and accommodates different situations.
And actually they have brought the definition which should be handled under interpretation. Like a health surveillance plan means a plan put in place by an employer to monitor and assess. Then you go mental health services includes, you get it?
In legislative drafting, there are certain interpretations that you interpret under the section, and we have done that many times. So this is also okay. For purpose of that particular clause, you interpret there.
So we agree that this is a new substitution. New substitution.
Right Honorable, let us be careful. Substitution presupposes that you are removing the other one. No. We are amending, we are adding to what exists. Right Honorable, give me the... Right Honorable, if you read the 21, which you've just read for us, of the Principal Act. (21) of the Principal Act. Right Honorable, 21, 1A, B, C, and D are okay. Here the proposal, I read A. A pre-assignment medical examination of workers before I'm looking.
Yes, what you have read under 1A has now been redrafted under 2C.
To carry out a pre-assignment medical examination on the workers where assignment exposes the worker to danger. That is now on C. That is a substitution. Yes? Let's first finish from here. Okay, AG. So AG, what is okay?
It is a substitution.
Okay. I put a question that clause 21 be substituted as proposed. Those in favor say to the contrary, nay. The ayes have it.
Clause 6.
Chair.
Madam Chairperson, Clause 6 is amendment of Section 47 of the Principal Act. Clause 6 is substituted with the following. 6. Replacement of Section 47 of the Principal Act. The Principal Act is amended by substituting for Section 47 the following. 47. safe and healthy working environment. An employer shall ensure that the workplace is safe and healthy working environment. 2, an occupier or owner of the workplace shall put in place measures to prevent exposure of a person to hazards. 3, an employer shall, within the time prescribed by regulations made under this act, cause a safety and health risk assessment to be carried out. 4, an employer shall at least once every 12 months cause a safety and health audit of the workplace to be undertaken. Justification: to impose an obligation on the employer to carry out safety and health risk assessment, which is informative of the likely hazards and risks at workplace. To impose an obligation on the employer to carry out safety and health audit, which is a performance indicator for compliance to safety and health measures.
AJ.
I concede to this.
Minister.
Right, Honorable Speaker, we concede to this.
I put a question that clause 6 be substituted as proposed.
Chair, clause 6B reads that the employer shall monitor, and I've extracted the operative word monitor, the noise, dust, etc. What the substitution seeks to do is to introduce 2 words, which is assessment, the periodic assessment, and then the audit. Those are 2 different things. Monitoring means that there must be a mechanism to see that daily either the temperatures do not exceed a certain level or the pollution or something like that. So I want to propose that the original draft under 6 should be added to read to one of the to the new substitution, and reads as 5 as the last paragraph. That monitoring function should not be lost, because audit takes place.
Where is 6? 47.
No, it's in the bill. In the bill as it says the employer shall monitor the noise, dust, vibration levels, and other hazards as recommended by the risk assessment in the workplace. Now, in the substitution, the word monitoring has been omitted. We have replaced only with the assessment and audit. Now, audit takes place after 12 months. So the monitoring function should not be lost. And I'm proposing that we retain this and add into the new clause as the last paragraph, so that we don't lose that.
Chair.
I concede.
AG.
Yeah, the proposal beefs up the obligation on the employer. I concede.
Minister.
Right, Honorable Speaker, we concede.
I put a question that clause 6 be substituted with clause 47 as substituted as proposed by the chair, with amendment from Honorable Dur Naif Jonathan. Those in favor say on the contrary, nay. The ayes have it.
New clause.
New clause.
Madam Chairperson, there is insertion of new clause after clause 6. The bill is amended by inserting immediately clause 6 the following. Insertion of section 55A in the Principal Act. The Principal Act is amended by inserting immediately after section 55 the following. 55A, first aid needs assessment. 1, an employer shall once every 3 years prepare and submit to the Commissioner for approval a first aid needs assessment as prescribed by regulations made under this Act. 2, a person who contravenes subsection 1 commits an offense and is liable for conviction to a fine not exceeding 1,000 currency points, or a term of imprisonment not exceeding 2 years or both. For purposes of this section, first aid needs assessment means an assessment carried out by the safety and health practitioners of the first aid needs of a workplace. Justification to impose an obligation on an employer to carry out first aid needs assessment, which is informative of the first aid needs for workers as a result of injury resulting at workplace.
Jonathan, you have something?
Chair, my only problem is that this proposal seems to suggest that there are different first aid needs for injuries. That should be standard. And the minister, first aid, people can have different sets of injuries. You cannot predict that it is going to be their fingers today or the head. So the first aid is a generalized response mechanism. So the minister, by regulation, must be able to prescribe that in this facility, these are the first aid. You don't need to do an assessment on that particular one. So maybe
they should set the minimum requirements.
Yes, minimum requirements prescribed.
Yes.
So that is not left like first aid is something that can be weighed in a different situation. I don't know if the.
So you make the amendment.
No, since it's a new insertion. And we have said that the minister has powers to make regulations, so we don't need to make any provision.
Any provision to it. AJ?
I'm still struggling to understand what Honorable Jonathan Odul is trying to say, because the wording here is first aid needs assessment. You assess your needs based on the possible risks. The possible risks. And each workplace presents different possible risks to life. That's why there is a catchword, assessment.
AG, my point is that first aid is a standard response mechanism to either a medical emergency or you could call it a fire, etc. So must it be carried on a case-by-case basis? It shouldn't. Every workplace where it should be standardized, said there must be some minimum. You must have oxygen, you must have maybe this and this and this in place at every workplace. That's what I was saying. But if you think it's different, I have no issue. I was just trying to...
Yes.
Madam Chair, I think the AG is correct because every workplace differs. For example, schools, if you have a tall building, you are supposed to have a slide. But if you have a nursery school, you don't need. So every workplace, the first aid needs differs.
The heading of the new proposal is a first aid needs assessment.
And I agree with the AG's position.
Yes, Mubende.
Thank you very much, Madam Chair. Madam Chair, what this wants to address is the fact that every workplace assesses the first aid needs. When we talk about the audits, that is what the audits will be looking out for. So every workplace does its assessment, and then they are asked the basis on which they stood to decide that this is the first aid kit that we shall have at this particular workplace. Thank you.
Doctor?
Thank you, Madam Chair. Madam Chair, I tend to agree with the Honorable Odur, because assessment of the first aid, the needs there is a profession, not the work of the employer. It may even underassess, actually. So the standard is set by the minister, and what the worker has to do is comply with the needs as assessed by the minimum standard set by the minister.
So what amendment do you want us to make? You want to reject this new amendment? The needs assessment? Yes.
The gender minister can help us. I thought all this will fall under the risk management plan of any given workplace. We don't have to now start citing first aid, then response, then this, all that. Each and every workplace is meant to have a very bigger plan that will cover ABC, response, and all that. So with our little knowledge, we have a better word other than citing out as first aid needs assessment. Thank you.
Chair. Madam Chair. Madam Chair.
Yes, Sandra.
Thank you so much, Madam Chair. Madam Chair, may I stand here to support the position of the Attorney General? Because each and every workplaces have different settings and standards that must be followed. He gave an example of a nursery school and the other. But we are looking at, we are in the information age. The assessment that we need, for example, where we have computers and this very serious technological equipment might be different from others. So even Parliament is different. So the assessment must be across board and the standard must be prescribed differently depending on the different workplaces, Madam Chair. Thank you.
Chair. Thank you, Chair.
Thank you.
Chair. Thank you.
Let me hear from your lob first.
Right, Honorable, I think we are struggling with wording here. Some of the things being mentioned by colleagues do not amount to first aid. You know, there's precautions which ought to be in place in different work settings. That's not first aid. To aid escape, for example, tall building, whatever the case might be, that's health precaution, which is taken care of differently. If it is a swimming pool, for example, do you have floaters? Do you have rescuers? That's not first aid. That's precaution. Yeah, those are precautionary measures that have got to be in place. So I think we are mixing these things up. So first aid is standard in the sense that it is first aid. It's not, you go to a hospital to get specialized treatment. When you have an issue with the eyes, you go to an eye specialist.
Precaution versus first aid.
Yeah, the two are totally different.
Totally different.
Right, Honorable, I wish to concede because now it is clear first aid is after the fact.
Yes.
While precaution is pre.
Pre.
Thank you.
Madam Chair, first aid needs vary depending on the workplace activities and location. E.g., work over water can cause drowning, while work in mines can cause suffocation. So an employer or the owner of the business must assess their risks based on what they are doing and where they are.
That's precaution. Clause 7.
Chair.
Clause 7.
Meaning we have rejected, the other one is rejected. Clause 7.
Madam Chairperson, Clause 7, amendment of Section 69 of the Principal Act. Clause 7 is amended in the proposed paragraph B by substituting for the words is at rest or landing. The phrase comes to a complete stop at the designated landing. Justification. The provision was made in error and it is contrary to the practice where the gate of a cage should only open when the cage is at complete rest as a safety precaution.
AG. Honorable Odur.
I concede.
Minister?
We concede.
I put a question at clause 7 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 7 as amended.
I put a question that clause 7 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 8.
Clause 8, Chair.
Madam Chairperson, Clause 8, amendment of Section 71 of the Principal Act. Clause 8 is amended by substituting for paragraph A the following. A, by substituting for subsection 2 the following. 2, a lifting gear used to lift loads shall not be used unless a certificate of examination has been obtained from the manufacturer or a person authorized by the manufacturer. B, by inserting immediately after paragraph A the following. By inserting immediately after subsection 2 the following. 2A, a lifting gear shall be annealed in accordance with the safety and health risks assessment under section 47(3). C, by substituting for paragraph B the following. B, by substituting for section 3 the following. 3, notwithstanding subsection 2A, a rope or a rope sling shall, unless the rope or the rope sling is of a class or description exempted by the Commissioner by notes in the Gazette, be annealed at least once every year, or in the case of chains used in connection with molten slag, once every 6 months. Justification: to remove the limitation of having only lifting gears which lift loads exceeding 50 kilograms being tested and examined, and ensuring that all the lifting gears used are in good state and safe for use.
Jonathan? AG? Minister?
Right Honorable, we concede.
Thank you, AG.
Right, Honorable. Just give me 1 minute. I'm trying to get the meaning of the word anneal before I concede. What does
It means to strengthen.
Okay, I concede.
I put a question that clause 8 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 8 as amended.
I put a question that clause 8 as amended stands part of the bill. Those in favor say on the contrary, nay. I put a question that clause 8 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 9.
I put a question that clause 9 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 10.
Chair.
Madam Chair, Clause 10, amendment of Section 73 of the Principal Act. Clause 10 is amended by substituting for the proposed Section 73 the following. 73, training and certification of persons who operate machines, plant, and equipment. A person shall not operate any machine, plant, and equipment unless the person is trained and certified to operate the machine, plant, and equipment as prescribed by the regulations made under this Act. An employer shall not engage a person to operate a machine, plant, and equipment who is not trained and certified. A person who contravenes subsection 1 or 2 commits an offense and is liable on conviction to a fine not exceeding 1,000 currency points or to a term of imprisonment not exceeding 2 years or both. Justification: to ensure that machinery and equipment used at the workplace is operated by a trained and qualified person.
Honorable Doctor?
Thank you very much, Madam Chair. The phraseology, I have a problem with the phraseology because it assumes that somebody must have been trained already to operate that equipment.
Yes.
But there are new equipments that come from time to time. We can say before he's trained. Before he's trained, because if the equipment is new, that person can be trained and then starts to operate it. But the previous phraseology presupposes that somebody must have got that qualification, that training, before even this machine has been invented. So because of advancements in technology and very many things being invented, coming on board, and they can be used, somebody can be trained before using the machine, not having been presumed to have been trained. That is what I'm saying.
Yes, Alepto.
Madam Chair, I have issues with subsection 3 about the currency points. Looking at the 1,000 currency points and the imprisonment of 2 years or both, I think looks to be a bit high, considering that if they're using the person who is not trained, and for example, the machine gets spoiled, that burden goes to the employer. It goes to the employer, although it might also pose the health hazard to the person who is operating it. But I feel like the currency point is really high and could be reduced to half of this, which would amount to 500.
I thought that would help you recruit trained people who are knowledgeable, who can be trainable. Yes, Aisha.
Chair, I was just counter-arguing with Honorable Olume. What he's saying is of no consequence here. It is well phrased. A person shall not operate any machine, plant, and equipment unless the person is trained. It is well constructed. You cannot say before the person is trained. That would be different. I don't know. The law, I know it is well constructed. It all means, Chair, that no person that is not trained can operate a machine. So once you bring in a machine, you are under obligation to train the person. It's
Honorable members, I want to refer you to section 73 on training. There is already an aspect of training provided for in the law. Yes, AJ. The issue of training is not an aspect, it is already provided for.
Right Honorable, I believe the phrasing, the clause, the wording in every way is spot on.
Pardon?
I believe the wording of this clause is spot on. All 1, 2, and 3 are perfect. I pray that we carry them as they are.
In the bill. Minister.
Right Honourable Speaker, we concede.
Yes, you want to make an addition?
Madam Chair, in the parent bill, the Principal Act, the bill mandates the minister under specific types of machines to demand and require training of the operators. In the proposal, they have opened up to any machine,
yes,
any equipment,
yes,
and you have to be trained and certified. But there is no space for on-the-job training, why there's no certifications. So how do we capture? Because there are many people who are employed and
but before you're qualified, will you be able to operate that machine?
Depending on the type of professional area, you can have people who are trained as apprentices and they don't undergo certification as required by the bill. So how do we address?
Now, that is provided for under education.
It's still unclear.
Right, Honorable.
Very strict.
If I may depart from
Remember,
my-
this one is on safety. Eh? No.
Right,
Yes.
Honorable. My colleague has used the word apprentice. I do not think in this case, the bill we are looking at, an apprentice is a learner, is a student doing clerkship or internship, okay? Now, in terms of health, you are not going to get a student and consider him an employee for purposes of this act. One says a person shall not operate a machine, plant, or equipment unless that person is trained and certified. So you do not have to be an apprentice. You must be
Honorable,
trained.
maybe I could just get to know what is the bill is on what? What is the bill on? Occupational hazards, safety, and health. Meaning you're already working. You're working. So we are now mining about your health, your safety. You get it, eh? Yes. We are not now teaching you.
But they may bring new machines.
We are now not teaching you. If they bring machines, you'll be trained to use those machines. Yes.
My concern is for the demand for certification, because there are people who are going to be trained across the work field of Uganda who do not necessarily receive certificates for their training. So I'm saying, how do we include them? Because they have been trained either on the job or through apprenticeship, but they have gained the skills, but they do not have the certificates. How do we cater for them? Thank you.
I thought that was a product of education and certification. That's a product of education and certification. You get it, eh? They have already approved.
Right, Honorable Chair. I'm looking at the report for last year.
So are we going to ask the minister to come with a curriculum? Yes, you're reading what?
Right, Honorable Chair. I'm looking at the report for last year. Out of the 1,000 accidents we had, 997 accidents were caused as a result of untrained operators. Then we must also require employers train their employees. Apprentices are not supposed to be employed as machine operators. They are there to learn, not to operate machines.
Honourable members, I put a question at clause 10 be amended as proposed.
Right, Honorable Chair, this is when we are talking about workplace, as if we are limiting it to an industrial setting. Let's assume you are in a medical facility and you are operating an X-ray. An X-ray, those machines and etc. Some of them can also be dangerous. Are they saying that this ministry can actually prescribe the training and certification required?
No, they can't.
Yeah, so this clause 10 should actually be deleted. I'm moving an amendment that should be deleted.
Wait. Clause 10 of the bill is on training of machine, plant, and equipment operators. And it says the minister may make regulations for the training and certification of machines, plant, and equipment operators. That is where. That's what Honorable Dur is saying. We should what? We should delete. Yes.
Chair, I think the problem is that in the parent law, 73 was talking about training of crane drivers. So in mind, we've been talking about crane drivers.
Crane drivers.
But when they made the amendment, they are now talking general about machines, operators.
Where does the minister get how can the minister certify?
Yes, I agree. I agree with the amendment in wholesome as far as crane drivers are concerned. But their heading does not have crane drivers. Their heading is general for machines, equipment, training, and certification. So the problem is with the heading. If you put back the heading for crane drivers, all the amendment is perfect that they made.
So is there any problem with us maintaining clause 73 as it is? From the parent law.
Yes, the parent
73.
law. The parent law was a bit funny because in the parent law required the minister to make regulations for training of crane drivers. And assuming that there are no training schools, there's nothing, the minister needed to make regulations. So I think that was a problem also in itself. It had a problem.
So what is the amendment? Yes.
Madam Chair, what is envisaged in this clause is to expand our scope beyond
Crane
cranes,
drivers.
because there are all manner of machinery involved. And the obligation is on the employer to make sure he employs people who know how to run those machines.
So who does the certification? Yes, Aki.
Madam Chair, the parent law is only talking about one equipment. But now we have expanded.
And you're all standing like you're looking after cows.
Thank you, Madam Chair. We are now empowering the minister to make regulation. That regulation, the training institution must comply with. Because there are so many training institutions.
Interministerial. In the regulation, she can say certification will be done by Minister of Works, that kind of thing.
Yes, you have really summarized it. Thank you.
Yes, Doctor.
Madam Chair, I would want to concede on training, but you will complicate and constipate work if at all you add certification. Because who is going to do the certification? You are trained to, like Honorable Dur said, you are trained as a radiographer. A new X-ray machine has come, a new one. So you want the minister to prescribe another course for certification in that. And there are not, and there are many, a multitude of them. How are you going to do it? Which training institution? The training institution may not be around. You're a heckler.
Thank you. Madam Chair, training and certification, the regulations will prescribe who will do it. It can be ministries, but I want to emphasize even a manufacturer can do training and certification. We got new CT scans as a country, new digital x-rays, and there was no institution trained on it, but the manufacturer came trained and did the certification itself. So the regulations will address it.
Thank you. Yes, AG.
You see, to respond to Honorable Urume, would be wrong to separate the word training from certification, because certification is intended to attest or prove that you have been trained. So you cannot separate the two. That's why you are required to produce a driving permit to show that you are allowed to drive. Otherwise, without the permit, it is questionable whether or not you are permitted to drive.
Honorable members, I put a question that clause 10 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 10 as amended.
I put a question that clause 10 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 11.
I put a question that clause 11 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 12.
Chair.
Madam Chairperson, Clause 12, amendment of Section 76 of the Principal Act. Clause 12 is amended. A. In paragraph A, the proposed paragraph C, by substituting for the phrase kilograms per square centimeters, bars, kilopascals, Newton per square meter, pounds per square inch, the phrase internationally recognized units of pressure. B, by substituting for paragraph B the following. By substituting for paragraph D the following. D, at least one water gauge of a transparent material or other type of approved by the Commissioner to show the water level in the boiler and where the gauge is of the glass tubular type of the vessel is under pressure, the gauge shall be provided with an efficient guard that does not obstruct the reading of the gauge. Justification: to adopt the use of internationally recognized units of pressure.
Right, Honorable Speaker, I take note of and concede with the amendment proposed on Clause 12 for the adoption of the internationally recognized units of pressure.
Thank you, Doug.
I am in total agreement.
I put a question that Clause 12 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 12 as amended.
I put a question that Clause 12 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 13.
13.
Madam Chairperson, Clause 13, amendment of Section 78 of the Principal Act. Clause 13 is amended by substituting for the phrase bars, kilopascals, Newton per square meter, or pounds per square inch, the phrase or other internationally recognized units of pressure. Justification: to adopt an encompassing term for all internationally recognized units of pressure rather than giving examples.
Doug?
I concede.
Minister?
I concede, Right Honorable Speaker.
I put a question that Clause 13 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 13 as amended.
I put a question that Clause 13 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 14.
Minister, Chair.
Madam Chairperson, Clause 14, amendment of Section 80 of the Principal Act. Clause 14 is amended by substituting for the phrase bars, kilopascals, Newton per square meter, or pounds per square inch, the phrase or other internationally recognized units of pressure. Justification: to adopt an encompassing term for all internationally recognized units of pressure rather than giving examples.
Minister?
Right Honorable, we concede.
Thank you.
I'm in agreement, Right Honorable.
I put a question that Clause 14 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 14 as amended.
I put a question that Clause 14 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it. 15.
Clause 15.
Madam Chairperson, Clause 15, amendment of Section 84 of the Principal Act. Clause 15 is amended by substituting for the proposed section 84.3 the following. 3. An occupier of a workplace using electricity shall annually cause the workplace to be inspected by a person authorized to inspect electricity in a manner prescribed by the regulations made under this Act. B. By deleting the proposed section 84.4. Justification: to provide for clarity on the duty of occupier to maintain safety of the workplace using electricity. The deletion of the proposed section 8.4 is a consequential amendment having recasted the proposed section 84.3.
Yes.
Madam Chair, I thought the intention is about the energy, the risk resulting from energy. Why do you only focus on electricity? Because we have gas and other sources of energy. Have you taken care of that in other sections? Uranium and all others. Why don't you put all the energy? Coal is very serious, gas and others.
Right Honorable, I want to agree with my Honorable colleague Kanya that we can expand this to include other energy sources that we use in the workplace that could be risky, like gas. There are some workplaces that use a lot of gas, and if it is not regularly inspected, it could cause an explosion and be hazardous. So maybe our draftsperson can reward this in addition to electricity, and add other probably hazardous energy, potentially hazardous sources of energy.
Person, this clause is looking at section 84, which talks about electricity. But if you go, you will find that they have gas plants and all other covered under within the Act of Parliament, the Employment.
Because that is electrical safety.
Chair, on the same amendment, there's a section amendment I thought we could add on an addition, because on most of the other countries, especially abroad, there is a date displayed on every electrical equipment or any equipment, the date showing exactly when it was checked, so that even if an employer is coming to use the equipment, there is at least a tag showing when it was checked, and that is not here, so that he knows that this is an expired equipment which needs to be checked, and he cannot use it. So I think we should include something which shows that a tag must be attached to the equipment which has been.
That is operational. That's operational. Like we have these fire extinguishers. They have to be serviced, and they will put a tag when they last. But what is important is you must have a fire extinguisher. You get it, Chair, what were you saying? What were you clarifying?
Is responding to the issue where they were saying we can add more, but they already catered for in the Act. In the
under 84.
82, gas is covered.
82, 83, 84 is provided for. That is what? So you okay?
I'm glad the chair has clarified. I concede.
Minister?
Right, Honorable, we are in agreement.
I put a question at clause 15 be amended as proposed. Those in favor say on the contrary, nay. Nice, have it.
Clause 15 as amended.
I put a question that clause 15 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 16.
Chair Christine.
Madam Chairperson, Clause 16, amendment of Section 98 of the Principal Act. Clause 16 is substituted for the following. Amendment of Section 98 of the Principal Act. Section 98 of the Principal Act is amended A by substituting for the head note the following: duty of suppliers, manufacturers, importers, and distributors. B, subsection 2 by inserting immediately after paragraph C the following: D, hazardous substance, mixture of substances, expired content, empty containers, or related articles of hazardous products after their use are safely disposed in accordance with the National Environment Waste Management Regulation 2019. Justification to remove the ambiguity to in the head note. That's it.
Honorable Minister.
Right Honorable, we concede with the new amendment clause on clause 16 to remove the ambiguity. On the head note and address the disposal of hazardous substances.
Thank you.
Clarification.
Yes. What I remember is when you're looking at the bill, you should also be able to look at the parent act. And what is being done here, they are only adding the D. Adding Yes.
Yes, Madam Chair. I'm looking at the word related articles of hazardous products. Looks kind of weird. I'm thinking it's supposed to be particles of hazardous products. I need clarification on that.
The wording is correct, related articles, because there are so many, you cannot describe them in one. Yes. Other than that, I am in agreement with the committee.
Thank you. I put a question that clause 16 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 16 as amended.
I put a question that clause 16 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 17.
S 17, deletion. Prime Minister, I don't hear you voting.
Madam Chair, Clause 17, amendment of Section 119 of the Principal Act, delete Clause 17, justification to ensure compliance with the provisions of the Principal Act.
Yes. AG.
Right Honourable Speaker and colleagues, on this I disagree with the committee. It is our position that subsection 1 be maintained. Right Honourable Speaker.
Honourable Member. What the committee is doing is to delete the amendment which was brought, which says amendment. The Principal Act is amended in Section 119 by substituting for subsection 1 of the following. 1, the minister may make regulations for implementation of this act. That's what they are deleting. However, the 119 says, 1 says, the minister may, with approval of Parliament, make regulations for implementation of this act. We are maintaining the Principal Act. We are maintaining the Principal Act. It's not anything for debate.
Yes, thank you.
We are maintaining the Principal Act.
Yes, yes, shall.
Right, Honorable Chair. I think it's important that Parliament is involved in this process. But as we discussed earlier, and the Minister committed, I had somebody calling her a good minister. The good minister committed to be bringing those regulations. I think let's enforce it within the law to actually say shall. Yes. So that it's no, you see, once we leave it as may, 10 years later, as has been the case with this Parent Act, you cannot blame her entirely. She says, but the law says may, so I chose not to. So I think let's rectify that, right, Honorable, and make the amendment.
So the amendment in 17 is that we are substituting the word may with the shall. In section 1191 of the Principal Act. Those in favor say on the contrary. Timeline, 3 months.
Yeah, Chair.
We agreed 3 months. Yeah.
Chair.
Yes.
I beg to differ in the following terms. Such provisions are made generally to allow the minister take care of unforeseen circumstances. Remember, in all the provisions we have passed, we say the minister make regulation. So this is an open one. In the event that in implementation, the minister desires. That's why they use the word may, because here we are not specific. Which regulation are you commanding the minister to bring? That does not exist. If you wanted to use shall, we are going to use it where we have expressly provided that this regulation. This is a generalized regulation. So you cannot say shall when you don't know which regulations you are requiring. But the approval of Parliament, it's okay. So that
Members,
Chair.
listen to Honorable Dur, because there are some aspects that may not require regulations. You get it, eh? There are other aspects that may not require regulations. That's why he's maintaining may. Okay.
Right, Honorable, I do hear him. You see, the thing is, if you're taking care of an aspect within the law, then there's no need for the regulation at all. So I think where my brother is saying that for us to have shall, then we should have mentioned that within the Act. So why bring a regulation if it's already taken care of? So maybe if you can clarify.
Chair, there are so many provisions. For example, we had said that an employer must do an assessment. I think we call it risk assessment or something. And then we say the minister will make regulation. Now we are specific. There is an assessment. So we can command the minister shall make regulation for that assessment. Now we have done that in so many provisions we have passed. But here in legislative drafting, you allow the minister some latitude. In case you go and implement and you find that there is one aspect that we have not addressed, the minister may then exercise the discretion to make a regulation. But because Parliament wants to have a say, then you say, come to Parliament. If you make it shall, it is like redundant. What are you directing me to do? The minister can ask you, even here, okay, you are telling me the minister shall make regulation. Now you tell me on what? That's the explanation I wanted to offer.
No, I think we are going to have more discussion on this.
No, we are having an interaction.
Yes, allow me add this. I noticed that every time we are handling a bill, when it comes to a point of making regulations, there's a push and pull. And the mischief my colleagues always bring up is that ministers have been required to make regulations in laws which they have not necessarily made. But I want you to understand, just like Honorable Dul has said, these regulations are supposed to be made to put in effect certain clauses to fulfill the intention of the bill, of the law that you are making. But in the event that it is not necessary, then you do not need to make those regulations. Now, the obligation then should be on Parliament, Right Honorable Speaker, to audit the laws we have passed that require regulations. Let a committee look at those laws and see which ones actually are long overdue. Then that can be done.
AG, let me just ask this clarification to the AG, right, Honorable Chair.
No. Just a minute. When you give the responsibility on Parliament, you as a member of Parliament, you know your roles. Is legislative scrutiny on regulations one of your roles as a member of Parliament? No, I need an answer first.
Okay.
Because people should not sleep on their duty, on their jobs, and you want us to do it for you. Attorney General, please, we can't do that.
Madam Chair.
Yeah, I am still waiting for feedback on the microphone from AG. No.
Right, Honorable, I agree with you. I concede.
Thank you. Yes, Globe.
Right, Honorable Speaker. Maybe let me also ask the Attorney General a question regarding this particular law we are dealing with. Does he think there is need for regulations? Because that will help us. And that's why on my end I'm insisting on the shall. If there is no need at all for any regulations in all the sections of this law, then there's even no need to talk about regulations. But if there is need for regulations, even if it is on one particular section, then we must get the commitment of the minister. How? By saying shall, the minister shall bring those regulations. So maybe the Attorney General needs to help us. This particular law, forget about the many which was saying we should audit and so on. There can be time for that. But this one that we are dealing with, is there a need for any regulations?
Madam Speaker, I want to respond to the law, to the Right Honourable Leader of Opposition. There is a need for regulations to actualize or activate some of the provisions of this law. So I am in agreement. My concern is on the use of the word shall. Because we do not know when the requirement for the regulations will fall due. If you, no. Yes, I'm in agreement that we need the regulations. But my humble prayer to this House that we use the word may. But Right Honourable Speaker, before I leave, Right Honourable Speaker, just 1 minute. When you read the clause earlier, you said with the approval of Parliament. Actually, for me, that's where my contention is. My contention is on the requirement for approval of Parliament. For the minister to come to Parliament for approval.
Honourable members, I am putting a question that clause 17 be deleted as proposed. You know, when we delete clause 17, we maintain what is in the parent act. What is in the parent act with approval of Parliament. And when you look at what Honorable Duro was saying, we can have different regulations. This is a general regulation, which may not even be made. If you have made a specific regulation, which is already required, there are regulations that can be specific. And this, the one we are looking at, is a general regulation for the act, general. So having a may not infringe on your rights. But what is important here is for an approval of Parliament. Yes?
Right Honourable, for me, I would move to amend by removing the word approval of Parliament. Permit me give justification. No, we are not taking away the powers of Parliament. The obligation would be on the minister.
You justify.
Okay.
Justify.
Permit me to justify. Right Honourable Speaker, I know that in allowing the minister to make regulations would promote. Right Honourable Speaker, allowing the minister to make regulations under this act without the approval of Parliament will promote efficiency. The process of approving statutory instruments in Parliament requires time. For example, the statutory instrument may be sent to a sectoral committee for scrutiny and comments, presentations of a report on the statutory instrument, and that will require time. Therefore, this delay may defeat the purpose of preparing the statutory instrument under this act to address an emergency relating to occupational safety and health of workers. I want you to note, Right Honourable Speaker and colleagues, some acts require ministers to make statutory instruments. I need to be protected, Right Honourable.
You're protected.
I want you to note, colleagues, there is an exception. Some acts require the ministers to make statutory instruments with the approval of Parliament. This is because the statutory instrument, those statutory instruments affect the core mandate of Parliament and require the consideration of approval and approval of Parliament. For example, a statutory instrument made under the Tax Procedure Code Act. Right Honourable Speaker, Odur, I really want you to listen to this. A statutory instrument made under the Tax Procedure Act for purposes of amending Schedule 2 relating to tax laws and Schedule 4 relating to amounts of turnover in respect of which audited financial statements are required. Accordingly, the statutory instruments under the Tax Procedure Code Act relate to appropriation or the budget, which is the core mandate of Parliament. Such statutory instruments cannot be made without the approval of Parliament. But this is different. this does not affect the core mandate of
Thank you.
Parliament.
Thank
I beg
you.
to submit.
Honorable members, what Attorney General, you've heard what Attorney General is saying. You've heard? We don't need to. We don't need to approve because our committees may take long with what? With the. No, I'm going to put a question. No, I'm going to put a question. Because our committees may delay, but as a presiding officer, I will make sure that these people don't delay. Now I put a question.
Right Honorable. Right Honorable. Chair, let me make this clear to the Attorney General. And I want Chair you follow. You see what we are doing under Article 79. No one can make a law other than Parliament. Now, when we, the owners of the law, give you powers, you cannot tell us, you don't know, you give me the power. It is us to either give you or even refuse it. So what you are trying to do here is to condition us to give you, yet we are the ones thinking, should we give you? So it doesn't. I need to respond to you so that you understand that. Yeah.
Chair.
Honorable members, I want to put a question. And the question I'm putting, those who are going to be in favor of AG's proposal, are we together? Those in favor of AG's question of saying that the minister shall make regulations without parliamentary approval because of the delays in the house where he sits, meaning that he's one of the people who delay, the answer should be no. But if you're in for what he says, you say aye. Are we together? I am putting a question.
Chair, what we have, the proposal by the Attorney General is in the bill. It's already in the bill under Clause 17. That is Attorney General's position. But the question is, there is an amendment for a deletion proposed by the committee. So we must first dispose of. No. The committee, we must first dispose of the committee's position. If the committee's position carries the day, there is no need to put the question on the attorney. It falls automatically.
Chair, with your permission, let me help Honorable Dole. The bill proposed that regulations be passed without the consent of Parliament. That's what is in the bill, okay? Now, the committee is disagreeing with the bill, and therefore the committee is proposing that Clause 17 be deleted. So once the question is put whether Clause 17 be deleted, and we say yes, we shall have thrown away the proposal of the Attorney General.
Chair. Chair.
Honorable members, the suggestion of Attorney General, he was giving a justification for Clause 17 not to be deleted. Are we together? That is the justification was given. But I am asking a question on the report. Committee amendment. Are we together? If you're in favor of the committee amendment, you say aye. Because the committee amendment, when you delete it, we still remain with the other one. Or we preserve the 119. Okay? On the 119 is a may, not shall.
Yeah, but there is a word approval that I want removed.
No.
Approval of parliament.
No. No. Honorable members, I put a question that clause 17 be deleted as proposed by the committee. Those in favor say and the contrary nay. The ayes have it.
Clause 18.
18, Chair.
Madam Chairperson, Clause 18, amendment of Section 120 of the Principal Act. Delete Clause 18, justification. The Occupational Safety and Health Board established under Section 10 of the Principal Act is amended to give expert advice, is mandated to give expert advice to the Minister, and so the approval of the board for the amendment schedule is part of the expert advice that they give the Minister.
AJ? Minister?
Right, Honorable Speaker. I take note of and consider with the new amendment proposal on Clause 18 to delete the previous amendment and ensure that the OSH board is operationalized.
Thank you, AG.
I'm in agreement.
I put a question that Clause 18 be deleted as proposed. Those in favor say and the contrary nay. The ayes have it.
Title.
I put a question that the title stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Motion for resumption of the House. Clause 1.
Clause 1. That's why I wanted you here.
Madam Chairperson, Clause 1 is amended by inserting immediately after paragraph C the following, by inserting the following new definitions in the appropriate alphabetical order. Safety and health audit means an audit carried out by the safety and health practitioner to evaluate the safety and health standards, policies, systems, and procedures of a workplace. Safety and health practitioner means a person registered and licensed under Section 16A to conduct a safety and health risk assessment, safety and health audit, or any other assessment or audit required under this Act. Safety and health risk assessment means an assessment carried out by the safety and health practitioner of the hazards or risks that may cause harm to a person at the workplace. Justification to define words and phrases that have been introduced in the bill.
Minister, AG.
I am in agreement with the committee. This clause defines certain aspects of the law.
Why are you speaking so softly? What happened? Minister?
We concede.
I put a question that clause 1 be amended as proposed. Those in favor say, and the contrary nay. The ayes have it.
Clause 1 as amended.
I put a question that clause 1 as amended stands part of the bill. Those in favor say, and the contrary nay. The ayes have it.
Motion for resumption of the House.
Right Honourable Speaker, I beg to move that the House resumes and the committee of the whole House before the report thereto.
I put a question that the House resumes and the committee of the whole House reports thereto. Those in favor say, and the contrary nay. The ayes have it.
Report of the Committee of the Whole House.
Honourable Minister.
Right Honourable Speaker, I beg to report that the Committee of the Whole House has considered the Occupational Safety and Health Amendment Bill 2023 and passed it with amendments.
Motion for adoption of the report of the Committee of the Whole House.
Honourable Minister.
Right Honourable Speaker, I beg to move that the report to the Committee of the Whole House be adopted.
I put a question that the report of the Committee of the Whole House be adopted by this House. Those in favor say, and the contrary nay. The ayes have it.
Bill's third reading, the Occupational Safety and Health Amendment Bill 2023.
Honourable Minister.
Right Honourable Speaker, I beg to move that the Occupational Safety and Health Amendment Bill 2023 be read the third time and passed into law.
Asumani. I put a question that the Occupation Safety and Health Amendment Bill 2023 be read a third time and do pass. Those in favor say, and the contrary nay. The ayes have it.
A bill for an act titled the Occupation Safety and Health Amendment Act 2025.
Title settled and the bill passed. Thank you so much.
Right Honourable Speaker, I want to thank you for chairing this session and also to thank the colleagues, members of Parliament who have endeavoured to stay here till the end of this. And I thank you so much for supporting us.
Right Honourable Speaker, I take this opportunity to thank you and thank the honourable colleagues, but in a special way to thank the members of Gender Committee who are present. My deputy is here for the work they have done, and thank you so much for finalizing this work. Yes.
Thank you so much, honourable members, and thank you for being here for all this long. I know passing a bill is not an easy thing, but we want to thank you for your endurance. I know you're all tired. For me, I can continue. Honorable members, we should be able to finish the rules first thing tomorrow. You should, tomorrow, Thursday, we shall finish with the rules. Chair rule, bear with us. We'll finish tomorrow. And then the rest of the time, we shall give it to the Prime Minister. I want to thank you, and the House adjourned to 2 tomorrow.
Tonight, billionaire Elon Musk facing questions for the first time over his cost-cutting moves. The major moment with President Trump in the Oval Office defending their deep government spending cuts as battles play out in the courts. What they said about the Democratic criticism of DOGE, why Musk says the federal bureaucracy should be slashed, and the president is asked, will he follow federal judges' rulings against him? The American teacher on his way back to the U.S. after being imprisoned for 3.5 years in Russia. What we're learning about the deal. 100 million under winter weather alerts, whiteout conditions in Kentucky, the nation's capital under snow, as West Virginia gets more than a foot, and where the next round is headed. Plus,
I never broke the law, and I never would.
The political stunner, the backstory of why the Trump DOJ is abandoning the corruption case against New York's Democratic mayor. What's behind the shift? The battle between the American tech giants and the global face-off for the future of AI. The tuna recall impacting major retailers across the country, what you need to know. And the good news, a gallery on ice you've heard of Burning Man is Minnesota's version, Freezing Man.
This is NBC Nightly News with Lester Holt.
Good evening and welcome. President Trump didn't have any kind words for judges who have paused some of his efforts to rein in government spending, saying today maybe we have to look at the judges. With Elon Musk at his side in the Oval Office, the president claimed without evidence that the sweeping downsizing effort has already exposed billions of dollars of government waste and corruption. He credited Musk, who in turn defended the propriety of his role as an unelected official given broad authority to reshape the American government from the ground up. Musk insisting he is accountable for his work, while the president said he would ensure the billionaire businessman steers clear of conflicts of interest. Gabe Gutierrez reports.
Tonight, tech titan Elon Musk with his young son in the Oval Office.
The country's going bankrupt.
Defending his aggressive push to downsize the federal government.
If you have rule of the bureaucrat, or if the bureaucracy is in charge, and then what meaning does democracy actually have?
But the leader of President Trump's Department of Government Efficiency, or DOGE, the wealthiest man in the world whose businesses have massive federal contracts, was also pressed about potential conflicts of interest.
All of our actions are fully public. I fully expect to be scrutinized and get a daily proctology exam, basically. Might as well just camp out there. So it's not like I think I can get away with something.
Following criticism from Musk, the Department of Homeland Security today firing several FEMA workers, accusing them of circumventing leadership by using taxpayer money to pay for New York City hotels for migrants.
The public is saying, why are we paying all this money? This for years, this has gone on.
But Musk was pressed about what Democrats call a hostile takeover of government.
You couldn't ask for a stronger mandate. The people voted for major government reform, and that's what the people are going to get.
Democrats also argue a constitutional showdown may be brewing as the Trump administration faces mounting legal challenges over its cost-cutting moves.
Public employees who serve this country well. You should be respected.
not rejected.
Over the past week, judges have temporarily hit the brakes on President Trump's freezing of some federal spending, which was challenged by several blue states, and offering federal workers buyouts opposed by some unions.
And now a judge who's an activist judge wants to try and stop us from doing this. Why? Why would they want to do that? I campaigned on this. I campaigned on the fact that I said government is corrupt. And it is.
Today, Vice President J.D. Vance in Paris after suggesting judges aren't allowed to control the president's legitimate power, setting up a new battle over presidential authority.
The issue here isn't the courts trying to control the president. It's the president trying to control the law.
I agree wholeheartedly with Vice President J.D. Vance. What DOJ is doing is making sure that your taxpayer dollars, all of us, are spent in the way that they're intended to be spent.
President Trump tonight.
Maybe we have to look at the judges. I think it's a very serious violation.
Saying he'll follow court rulings.
I always abide by the courts, and then I'll have to appeal it.
Gabe, you also have new reporting tonight on two of President Trump's cabinet picks.
Yes, Lester, the president's choice for director of national intelligence, Tulsi Gabbard, just picked up support from two key Republicans. Her confirmation vote was expected overnight, but this snowstorm is delaying it. Robert F. Kennedy Jr.'s confirmation vote could also come later this week.
All right, Gabe, thanks. Enjoy the snow. Now to the surprise announcement. American teacher Mark Fogel, who was held in Russia for 3.5 years, is heading home. The Trump administration is securing his release. Garrett Hake joins us now. Garrett, Fogel will be arriving in Washington later tonight.
That's right, Lester. Fogel is flying back as we speak. A White House official posting this photo of him aboard the private plane of Trump special envoy Steve Witkoff, who led the negotiations for his release in Moscow. The Pennsylvania native was sentenced to 14 years in prison for possession of cannabis, which his family says was to treat back pain. The U.S. considered him wrongfully detained. President Trump said today the U.S. gave Russia, quote, not much in return for Fogel's release. Fogel's family saying they are beyond grateful he's coming home. Lester.
All right, Garrett Hake tonight. Thanks. Let's turn now to that high-stakes meeting at the White House between President Trump and Jordan's King Abdullah, where the president doubled down on his controversial plan for Gaza. NBC's Andrea Mitchell has late details for us.
Jordan's King Abdullah at the White House after President Trump threatened to cut off aid to Jordan if the king doesn't take in Palestinians from Gaza, which Jordan has opposed. King Abdullah offering instead to take in thousands of sick children from Gaza.
I think one of the things that we can do right away, 1,000 children that are either cancer children or in very ill state to Jordan as quickly as possible.
That's really a beautiful gesture. That's really good, and we appreciate it.
The president also doubling down on his plan to own Gaza and rebuild it.
We're not going to buy anything. We're going to have it, and we're going to keep it, and we're going to make sure that there's going to be peace, and there's not going to be any problem. I can tell you about real estate. They're going to be in love with it.
King Abdullah saying Egypt will present a plan in response to the president's, who then suggested he won't withhold aid to either country.
I don't have to threaten with money. We contribute a lot of money to Jordan and to Egypt, by the way, a lot, to both. But I don't have to threaten that. I think we're above that.
Meanwhile, President Trump also doubling down on his threat to Hamas after seeing how emaciated 3 Israeli hostages were when they were released last week.
They look like Holocaust survivors.
The president repeated his demand that Hamas not just release a few hostages this week, but all of them by noon Saturday.
They either have them out by Saturday at 12 o'clock or all bets are off.
Israel's Prime Minister Netanyahu has put his troops on alert along the Gaza border, saying if Hamas does not live up to their end of the hostage deal on Saturday, Israel will resume intensive combat operations. Lester?
Andrea Mitchell, thanks. Over 100 million people are under winter alert, stretching from Colorado to Maine. Tonight, the White House under a cascade of snow, as you saw a few moments ago. Sam Brock is in Washington, and Sam, the first wave of snow already coming down there pretty hard.
Yeah, Lester, as you can see, it is really coming down, as you said, right now and starting to stick. Projections for Washington, D.C., somewhere in the range of 4 to 6 inches. And Lester, other parts of the country are getting absolutely walloped right now, like Kentucky, which is seeing blinding snow on its highways. West Virginia has already received more than a foot of snow. And Arkansas, which is buckling under an ice storm. This is the first, Lester, of back-to-back-to-back storms impacting the Mid-Atlantic, the Midwest, and Great Lakes Lake regions and the Northeast, with this weekend expected to be awfully messy. Meantime, back here in D.C., for hundreds of thousands of families, school and access to open roads is an open question. Lester, back to you.
All right, Sam, thanks very much. New York City Mayor Eric Adams is vowing to regain the public's trust after the Department of Justice dropped corruption charges against him. Tonight, there are questions about his political future and what it could mean for other high-profile prosecutions. Here's Laura Jarrett.
I never broke the law.
Mayor Eric Adams speaking out now for the first time since the Justice Department's decision to drop its corruption case against him.
I absolutely never traded my power as an elected official for any personal benefit.
Top DOJ official Emil Bovee directing federal prosecutors in New York late Monday to dismiss the bribery charges against Adams immediately, but leaving the door open to a future investigation. Bovee saying the case, indicted by a grand jury last September and set for trial this coming April, has improperly interfered with Mayor Adams' bid for re-election. The general election still 9 months away. Bovee also suggesting it restricted the mayor from devoting his full attention to the Trump administration's priorities on immigration and crime, raising fresh questions tonight about how the DOJ will treat criminal investigations going forward.
More serious in the long run is the damage this does to the whole idea of criminal prosecutions being separate and apart from the president's policymaking. This certainly is a message that any public official who is prosecuted, against whom charges are not dropped, simply hasn't made the right call.
Adams pled not guilty to charges of taking bribes in exchange for political favors, while President Trump appeared sympathetic to his case last year.
I think that he was treated pretty unfairly.
Adams later traveled to meet with Trump at Mar-a-Lago just days before also attending his inauguration.
And Laura here with me. Are there other prosecutions in New York that the DOJ could weigh in on?
Certainly, Lester. This is an office that routinely handles public corruption cases. Meanwhile, some defendants, like Senator Bob Menendez, hoping that the president will step in with a pardon.
All right, Laura, thanks very much. Now to a stunning moment on the floor of the House. A sitting member of Congress publicly accusing her ex-fiancé and several others of a long list of serious crimes. Ryan Nobles has the story.
South Carolina Congresswoman Nancy Mace taking to the House floor to publicly accuse 4 men, including her ex-fiancé, of what she described as heinous crimes against women, including herself.
I'm going scorched earth. So let the bridges I burn this evening light our way forward.
Mace, without specific evidence, spent close to an hour detailing allegations, including rape and filming women and young girls without their consent. She accused her ex-fiancé, Patrick Bryant, of being at the center of the scheme, which she says she uncovered on his phone.
I found myself face to face with the darkest corners of humanity.
Bryant, who Mace was engaged to until 2023, vehemently denied her claims. I categorically deny these allegations. I take this matter seriously and will cooperate fully with any necessary legal processes to clear my name. The other men named by Mace in the speech also forcefully denied the allegations and called them untrue. Mace also attacked South Carolina Attorney General Alan Wilson.
There were deliberate delays in an investigation in what I turned over.
Wilson, who could be a future political rival of Mace's in the South Carolina governor's race, said the Congresswoman has her facts wrong.
She's never voiced any concerns about her case. And had she raised any concerns, I would have been completely shocked because I was unaware that she had a case being investigated.
By giving her speech on the House floor, Mace has wide latitude under the Constitution's speech and debate clause, which protects members' comments from lawsuits. But those comments need to be part of legitimate legislative activity. Mace argued the allegations were part of her rationale for introducing bills related to the protection of women. A source with direct knowledge tells NBC News she consulted with a lawyer to make sure the speech was constitutionally protected.
Of the 4 men Mace made accusations about on the House floor, only one is under active criminal investigation, her ex-fiancé. The South Carolina Law Enforcement Division confirms there is a probe into allegations of assault, harassment, and voyeurism, but no charges have been filed. Lester?
Ryan, thank you. In 60 seconds, billionaire battle, Elon Musk looks to buy control of Sam Altman's OpenAI, and the feud between the two tech titans gets personal. What Altman said today about Musk. Next. In Paris today, an international summit on artificial intelligence. Vice President J.D. Vance was there arguing against strict regulation. But as Brian Chung reports, the drama between tech titans Elon Musk and Sam Altman took center stage.
Vice President J.D. Vance on the world stage today, sharing his vision of an America First agenda on artificial intelligence.
The United States of America is the leader in AI, and our administration plans to keep it that way.
But off stage, a more personal, escalating battle for AI supremacy. Elon Musk making a $97 billion offer to take ChatGPT maker OpenAI from its CEO Sam Altman, who Musk has called Scam Altman and a swindler. Altman punching back, offering to buy Twitter from Musk, and today at the AI summit in Paris saying,
probably his whole life is from a position of insecurity. I feel for the guy.
The growing public feud, now a major falling out between the two tech billionaires who co-founded OpenAI together in 2015.
I think we've got a really talented group at OpenAI.
You are unusually fearless and willing to go in the face of other people telling you something is crazy.
But now Musk's company xAI is a competitor to Altman's OpenAI.
I mean, look, OpenAI is not for sale.
The two are also fighting in court after Musk sued Altman and OpenAI, alleging that they double-crossed him on a promise to keep the company a nonprofit. OpenAI saying they need to become a for-profit company to raise money. Caught in the middle, President Donald Trump, close with Musk, but also heaping praise on Altman at a recent White House event.
I would say by far the leading expert based on everything I read, Sam Altman.
A former friendship gone foul with the future of AI hanging in the balance. Brian Chung, NBC News.
Now to a consumer alert. The FDA announcing a voluntary recall over the risk of botulism, a potentially fatal type of food poisoning for some canned tuna in dozens of states and D.C. sold at Trader Joe's and Costco. The FDA and the manufacturer say it's out of an abundance of caution due to a pull tab defect. Still ahead as we continue here tonight as the White House announces new orders on gender-affirming care. Our reporting on the personal side of the new legal landscape. Next. After a flurry of executive orders, families and doctors are now scrambling, trying to navigate what, if any, transgender care children and teens will be able to receive. Stephanie Gosk explains.
A campaign promise.
No serious country should be telling its children that they were born with the wrong gender.
Turned into a flurry of executive orders targeting transgender people and the institutions that support them. One of the recent orders bans federal funding of transgender medical care for individuals under 19.
Basically, me getting care is like my house. Imagine somebody's coming in, an architect who got the deed to your house and all this. We're going to take away your house.
Is that how you feel right now?
They're taking away all our houses.
17-year-old Akani Drisdale Ash has been getting transgender care, including hormone blockers, for 3 years.
I didn't feel connected to my body. It started maybe when I was in 4th, 5th grade.
For me as the parent, the most important part was like just getting connected with support for my child. My child is depressed.
Akani's mother took him to a clinic in New York City.
I think it's important to screen those young people to make sure that they understand, in particular when they're legally minors, to make sure that their parents understand.
Dr. Jeffrey Birnbaum treats Akani. He says he and his patients are afraid about where the country is heading.
I am certainly scared about what could happen to both me, my institution, and every other institution where young people are coming for care.
There are currently 26 states that have laws or policies that restrict gender-affirming care for minors. 6 hospitals in states where it is allowed have changed their policy, according to the White House. NBC News reached out to another 10 hospitals in states where it is currently allowed, and 2 confirmed their policies changed as well. The executive order is already facing legal challenges, and it's not clear how enforcement will work.
You have a government right now that is taking concrete actions
to prevent you from living the way you want to live. And I wonder, how does that affect you today?
It seems like we're history repeating itself. I will do what the people before me did, what we always will do. Stand up for ourselves, lift our voices, and come together.
Stephanie Gosk, NBC News.
And coming up tonight, while most of us are staying indoors, we'll take you to a frozen lake that has been transformed into a gallery on ice. There's good news to report tonight. It's next. Finally tonight, the good news in Minneapolis, where a band of artists transformed a frozen lake into an art gallery unlike anything you've ever seen. Here's Maggie Vespa.
Every winter, when the land of 10,000 lakes freezes over, make art happen! Stubborn Minneapolis artists turn one into the ultimate stage. Welcome to the Art Shanty Project's 20 interactive exhibits. The trippier, the better. On ice, for those who dare.
Yeah, it's very wild. I keep asking her, are we okay?
We do get a lot of frozen lake first-timers.
Frozen lake first-timers.
The festival began 21 years ago when a pair of artists learned frozen lakes lack building codes. Organizers measure the ice daily, topping the minimum 10 inches, not always a guarantee.
Last year, warm weather started melting the ice and the festival closed early. This year, they came back in full force.
On display, a play on the plight of pigeons. Dumpster fire disco.
Nod to wild stuff that's happening in the world right now.
Even Froga, frozen yoga.
It's like the opposite of hot yoga.
All drawing people together.
They never walked on ice before.
You've never walked on ice before.
In a season that normally drives us indoors.
Hello. That was so Minnesota.
On a stage where, while it lasts, anything goes.
Oh my God.
Maggie Vespa, NBC News, Minneapolis.
It kind of warms your heart, doesn't it? That's nightly news for this Tuesday. Thank you for watching. I'm Lester Holt. Please take care of yourself and each other. Good night. Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.
We're going to get started with the homecoming of an American teacher held by Russia for more than 3 years. 63-year-old Mark Fogel, who was sentenced to 14 years in prison for possession of medical marijuana, arrived last night at the White House and was greeted by President Trump, where Fogel expressed his gratitude for his family.
My family has been a force. I think my 95-year-old mother is probably the most dynamic 95-year-old on earth right now. And I am...
Department of Government Efficiency, more power over the federal workforce. We have team coverage ahead this hour, including the latest in the legal battle over federal funding. We'll get to that with Danny Savalos, but let's begin with NBC News senior White House correspondent Garrett. Hey, Garrett, good morning. So let's start with where we just started a moment ago, the return home of Mark Fogel. What do we know about the details of his release from Russia?
Well, Savannah, frankly, very little. The White House says these negotiations have been going on for a little while and that they hope they will be a sign of good faith for negotiations that might ultimately lead to the end of the war between Russia and Ukraine. But this involved a number of officials, notably Steve Witkoff, who's actually the White House's envoy for Middle Eastern negotiations. He's the one who flew. You see him there with the tan jacket, actually, with his back to the camera there at the White House. Flew on his own plane to Russia to pick up Fogel. Now, the Russians have indicated that this is part of an exchange, likely for one other individual, but the Russians aren't naming who that person is and kind of admonished the United States for how much of a show was put on here with Fogel. They seem to want to keep their end of the bargain here secret. So hopefully more information comes out about that today. But for right now, the Kremlin and the White House both aren't talking about what was at the other end of this exchange.
Yeah, President Trump teased also the fact that another prisoner could be released today, so we should eventually be receiving more information. Garrett, as we've mentioned, Paul Martin, that's the Inspector General of USAID, an organization we've been talking a lot about here. He's been fired. It comes after the agency released a report highlighting the dangers associated with a gap in staffing and lack of oversight after, of course, many of their employees were let go, and the agency has really been kind of cooled down. Walk us through what led to this move from the White House and what we think this means for USAID moving forward.
Yeah, kind of a don't let the door hit you on the way out sort of firing here from the White House, and who you'll remember in the first week of the Trump administration fired a number of IGs across other agencies in the government. It's not clear, and the White House has yet to respond to our direct questions about this, about whether the lack of firing the USAID Inspector General earlier was an oversight or whether this was someone who they had intended to keep on. But that Inspector General coming up with this one last bruising report about the effects on the agency of the moves that the administration was taking to basically shutter elements of it. I think with the White House's view here is that they're moving USAID entirely under the auspices of the State Department, that they probably don't need an Inspector General just to handle USAID matters going forward. But again, this kind of one last damning report about exactly what the human and material costs are of shuttering this agency while it's trying to do its work.
Absolutely. Garrett, also, I'm just asking you about it all here. The Trump administration continues to fill out its cabinet. So votes that had been planned for yesterday are expecting them today. Confirmed Tulsi Gabbard, that's President Trump's pick for Director of National Intelligence. Also Robert F. Kennedy Jr.'s nomination for Health Secretary. What do we think could happen today? Are there obstacles in their way that would mean that either of them do not move all the way forward?
Yeah, look, both of these votes looked like they were going to be a lot closer a week ago, but now it seems likely, if not certain, that both of these former Democrats are going to be confirmed to Donald Trump's cabinet, with the majority, perhaps all Republicans supporting. Folks like Susan Collins and Lisa Murkowski, who had voted against Pete Hegseth's nomination, have both come out saying that they intend to support both of these nominees. To the degree that there are wild cards remaining on the Republican side, they are, ironically, Mitch McConnell, the former majority leader, and John Curtis, who took Mitt Romney's seat in Utah. They've been more skeptical of these nominees and have a bit more of an independent streak based on different elements of their position in the party that could get them to vote no. But that's just 2 Republican no votes. If every other Republican sticks together, both of these nominees would be confirmed without J.D. Vance having to come back from Europe to cast a tie-breaking vote.
Garrett Haake, like I said, covering it all. We appreciate it. Thanks so much. Well, that fight over the future of USAID is one front in the brewing battle over the powers of the executive branch when it comes to federal spending. With Elon Musk at his side in the Oval Office yesterday, President Trump claims the downsizing effort has already exposed billions of dollars of government waste and corruption. NBC News senior White House correspondent Gabe Gutierrez has the details.
Tech titan Elon Musk with his young son in the Oval Office.
If we don't do something about this deficit, the country's going bankrupt.
Defending his aggressive push to downsize the federal government.
If you have rule of the bureaucrat, if the bureaucracy is in charge, and then what meaning does democracy actually have?
But the leader of President Trump's Department of Government Efficiency, or DOGE, the wealthiest man in the world whose businesses have massive federal contracts, was also pressed about potential conflicts of interest.
All of our actions are fully public. I fully expect to be scrutinized and get a daily proctology exam, basically. Might as well just camp out there. So it's not like I think I can get away with something.
Following criticism from Musk, the Department of Homeland Security firing several FEMA workers, accusing them of circumventing leadership by using taxpayer money to pay for New York City hotels for migrants.
The public is saying, why are we paying all this money? This for years. This has gone on.
But Musk was pressed about what Democrats call a hostile takeover of government.
You couldn't ask for a stronger mandate. The people voted for major government reform. And that's what people are going to get.
Democrats also argue a constitutional showdown may be brewing as the Trump administration faces mounting legal challenges over its cost-cutting moves.
Public employees who serve this country well. You should be respected, not rejected.
Over the past week, judges have temporarily hit the brakes on President Trump's freezing of some federal spending, which was challenged by several blue states, and offering federal workers buyouts opposed by some unions.
And now a judge who's an activist judge wants to try and stop us from doing this. Why? Why would they want to do that? I campaigned on this. I campaigned on the fact that I said government is corrupt. And it is.
Vice President J.D. Vance in Paris after suggesting judges aren't allowed to control the president's legitimate power, setting up a new battle over presidential authority.
The issue here isn't the courts trying to control the president. It's the president trying to control the law.
I agree wholeheartedly with Vice President J.D. Vance. What DOJ is doing is making sure that your taxpayer dollars, all of us, are spent in the way that they're intended to be spent.
President Trump.
Maybe we have to look at the judges. I think it's a very serious violation.
Saying he'll follow court rulings.
I always abide by the courts, and then I'll have to appeal it.
Our thanks to Gabe Gutierrez for that report. Well, so far, President Trump has not committed to seeking congressional approval for the massive overhaul of federal agencies he and Musk are pushing for. NBC News has learned that a senior official at the Federal Emergency Management Agency, that's FEMA, is getting swept up in the legal challenges over the president's attempt to exert control over federal spending. That official ignored a court order by instructing her subordinates to freeze funding for multiple grant programs. According to screenshots of an email obtained by NBC News, the official followed President Trump's memo calling for a freeze of federal funding. It happened on Monday, just hours after a federal judge issued a court order demanding that the Trump administration release those funds. In the email, which was shared by a recipient who requested anonymity due to fear of retaliation, a FEMA director told her team to pause funding for awards programs. It includes financial assistance for things like emergency preparedness, firefighting, and protecting churches from terrorism. The senior FEMA official who sent the email didn't respond to NBC News' request for comment. That was a lot there. So let's bring in Danny Zavala here on set to talk through it. Okay, so this is sort of like, correct me if I'm wrong, this is how federal employees are kind of getting swept up in this kind of tug of war between the president and executive power and these federal courts. This one particular employee following President Trump's orders, coming though after a court said, hey, that's not happening right now. Explain kind of the awkward legal position that some of these federal employees are in.
This is a really difficult spot because defiance of a court order is contempt. It could be even criminal contempt. There's civil contempt and criminal contempt. And individuals within the executive branch are far more susceptible to being held in contempt than the executive himself, than the president, because you run into all kinds of immunity and separation of powers issues. But I suspect that it would be much easier to hold someone in the administration liable or guilty for contempt. The problem is that person is probably also getting orders from his superior, his or her superior, saying, this is what you are directed to do. And now we have a classic, I was ordered to do it defense. Hopefully it doesn't come to that, but that is the conflict that we see potentially happening with these folks in the administration, not the president himself, but the people carrying out the policy.
This also comes as we've been playing for viewers this morning. We heard the comments from President Trump. Maybe we need to look at the judges if they are opposed to, cutting federal spending. It comes as Elon Musk. There's a picture right there, right now. He might be saying that in this picture when he said that this is what the people voted for and we're going to give it to them. For people who are hearing those comments and then wondering, so what are these judges saying? Why are they pausing this? Why are they saying that it can't go forward? What's happening?
Yeah, this is a centerpiece of Trump's statements. They're vague enough that you're not entirely sure what he means. When he says, look at judges, that could mean I'm going to appoint more judges that I like, which is perfectly fine. If it means something else, like ignoring what they tell us to do and ignoring court orders, that may not be so fine, at least constitutionally speaking. But going forward, until the administration gives an order to defy court orders, then, that could be a situation where we have that dreaded word constitutional crisis potentially.
There's been a lot of talk, like opinion columns, that kind of thing, where are we on this cusp of a constitutional crisis? Obviously there was specific ones like birthright citizenship, that kind of executive orders that directly were in conflict with the Constitution. Yesterday, we actually heard from a Supreme Court justice. This is Justice Sonia Sotomayor. She's a liberal justice. She weighed in on this balance of power issue, this question of how much executive power actually exists. Can courts check that? Let's take a listen.
Our founders were hell-bent on ensuring that we didn't have a monarchy. And the first way they thought of that was to give Congress the power of the purse. Court decisions stand whether one particular person chooses to abide by them or not, it doesn't change the foundation that it's still a court order that someone will respect at some point.
Danny, remind us of, we all grew up hearing the term checks and balances, how they come into play at a moment like this, and if we do kind of end up in a constitutional crisis, how that's ultimately litigated.
A lot of very smart people in the last 72 hours have written very thoughtful pieces about how we may be in a constitutional crisis. It may be I'm in the minority. I don't believe we're there yet because I have a sort of bright line. The mere fact that someone, the executive branch, does something unconstitutional is not a constitutional crisis.
Right.
The mere fact that the administration does something unprecedented or even outrageous is not a constitutional crisis. I think we should use that term sparingly because a constitutional crisis, in my view, only arises when there is a situation that the Constitution simply has no answer for. Requiring the courts to deal with a bunch of executive orders, not a constitutional crisis. That's what the courts are for. When a court issues an order and the president defies it, now we may be in constitutional crisis land.
All right, Danny Savalas, appreciate it as always. Thanks for being here. Now let's get to our other big story. This is that winter weather system sweeping across the United States. You might see it right outside your window. Multiple storms are bringing heavy snow and frigid temperatures to a huge swath of the country, creating messy and in some cases dangerous conditions. NBC News correspondent Adrienne brought us. She's in Kansas City. She is out in it for us. Look at the snow gathering on her hat. Adrienne, good morning. We appreciate you being out there. And you are in one of the areas expecting some of the worst weather over the next few days. So again, our thanks to you. What's it like out there right now?
As you see, Savannah, the snow is falling, and I can tell you we've seen this moderate snowfall for the last 2 hours or so. It's been steady and nonstop. Here in downtown Kansas City, you can no longer see the skyline. When I woke up this morning, I could see it, but that is not the case now. The roads are snow covered. You may be able to hear the sound of some folks working behind us. They're working to clear some of those side streets there. But here in Kansas, they're expected to get 3 to 6 inches over the next 2 days. And right now, we're in the heaviest period of this snowfall.
Adrienne, what are some of the biggest concerns as the storm moves through the area? I mentioned it can create dangerous conditions. What should people keep in mind?
Oh, certainly. Not just here in Kansas City, but across the country. At least 90 million people are under these winter weather alerts. And overnight, we saw some severe conditions. The big concern, snow and ice, for example, especially when those bridges ice over. We've seen video where people were sliding off of the road into ditches. We've seen cars flip over. That is one of the major concerns. Also with the ice in some parts of the country, it was so heavy, the ice blanketed the tree branches, causing those branches to fall and even bringing down power lines. Beyond the ice, the other big concern out west is the potential for flooding, especially in those areas that were hard hit by fire. The big concern is with the flooding and the debris possibly sliding away, Savannah.
Adrienne, how are officials preparing for the winter storm?
Not only here in Kansas City, but across the country, we've seen public works departments already preparing and getting ready. For example, on Monday here in Kansas City, they started pre-treating the roads, and their workers are working overtime. It's all hands on deck. They have hundreds of snowplows and more than 400 workers ready to work in those shifts and go out and make sure the main streets are cleared. But as you can see behind me, not a lot of people out on the roads right now. But for those who may be traveling, whether you're here or across the country, if you have to be out, take your time. Back to you.
Adrienne, please go get warm. Thank you so much. Well, let's get a closer look at how this series of winter storms could impact your area with your Morning News Now weather. Angie Lassman is back with us. She's here in studio. Angie, good morning. Welcome back.
Hi there, Savannah. Good morning. It's great to be back with you. We've got a whole lot to talk about. Multiple storm systems for the east, for the west. So let's start with the east. We've got these back-to-back winter storms that you heard Adrienne just mention. Storm number 1 is exiting, but we're still seeing a little bit of this kind of lingering snow and wintry mix. And of course, we've got the rain draped across parts of the south. And then we've got this next storm system system that's going to develop and continue to work its way east over the next couple of days. That is centered over the plains for now. So no surprise that we've got alerts across much of the country. 97 million people under winter alerts, and we've got those flood alerts topping about 15 million at this hour. One thing to note across the South today, 10 million people going to see the potential to have some of these stronger storms develop and maybe even spin up a tornado or two. We could see some strong winds close to 60 miles per hour or higher. The hail risk is low, but again, this includes Montgomery to Baton Rouge, so something to watch for through the afternoon hours and into the evening hours today. And boy, is this going to be a mess even as we get into the later parts of today and into tomorrow. Across parts of the plains and the Great Lakes, that's where you'll see the heaviest snow set up through the day today. It's the ice, the rain across the south and the northeast. And we're going to see that lasting even into the early hours of tomorrow morning. So across the northeast, it'll be a little bit difficult for that early morning commute. You'll notice the snow still sticks around for much of northern New England tomorrow, even into the later parts of the day. But most of the system is going to work offshore. We'll still see some of that snow lingering for parts of the Great Lakes too. And heavy at that, I think if people are traveling, especially on the roads or in the air, you're going to see some difficulty likely at some hubs. Places like Chicago could pick up anywhere from 4 to 7 inches. We'll see multiple inches in Detroit as well. Kansas City, similar story there. 3 to 6 inches is what we're expecting. And on top of that, the roads are going to be difficult for a lot of folks. Notice that 1/4 inch of ice accumulation across parts of the Great Lakes from Indianapolis up into the lakes. It'll be difficult on the roads, Savannah, and we could even see some power outages. And of course, we've got that rain that'll leave us with the flooding concerns for the South too.
Is that all?
No, actually, we've got stuff going on the West Coast too. Heavy rain. You heard Adrian talk about.
We'll talk about that a little later too. Angie, thank you.
You got it.
And turning back to Washington, in an extraordinary speech on the floor of the House of Representatives, Republican Congresswoman Nancy Mace of South Carolina publicly accused her ex-fiance and several others of a long list of serious sex crimes, allegations that they all deny. NBC News senior Capitol Hill correspondent Ryan Nobles has the story.
This was an unconventional speech on the House floor. Nancy Mace making serious accusations about 4 different men, and all 4 of them deny what she claims. South Carolina Congresswoman Nancy Mace taking to the House floor to publicly accuse 4 men, including her ex-fiancé, of what she described as heinous crimes against women, including herself.
I'm going scorched earth. So let the bridges I burn this evening light our way forward.
Mace, without specific evidence, spent close to an hour detailing allegations, including rape and filming women and young girls without their consent. She accused her ex-fiancé, Patrick Bryant, of being at the center of the scheme, which she says she uncovered on his phone.
I found myself face to face with the darkest corners of humanity.
Bryant, who Mace was engaged to until 2023, vehemently denied her claims. I categorically deny these allegations. I take this matter seriously and will cooperate fully with any necessary legal processes to clear my name. The other men named by Mace in the speech also forcefully denied the allegations and called them untrue. Mace also attacked South Carolina Attorney General Alan Wilson.
There were deliberate delays in an investigation in what I turned over.
Wilson, who could be a future political rival of Mace's in the South Carolina governor's race, said the Congresswoman has her facts wrong.
She's never voiced any concerns about her case. And had she raised any concerns, I would have been completely shocked because I was unaware that she had a case being investigated.
By giving her speech on the House floor, Mace has wide latitude under the Constitution's speech and debate clause, which protects members' comments from lawsuits. But those comments need to be part of legitimate legislative activity. Mace argued the allegations were part of her rationale for introducing bills related to the protection of women. A source with direct knowledge tells NBC News she consulted with a lawyer to make sure the speech was constitutionally protected. Of the 4 men that Mace made accusations about on the House floor, only one is under criminal investigation, her ex-fiancé. The South Carolina Law Enforcement Division saying that there is an active probe into allegations of assault, harassment, and voyeurism, but no charges have been filed.
All right, Ryan, thank you very much. Well, Steve Bannon, a longtime ally of President Trump, has pleaded guilty to felony fraud charges here in New York for helping to defraud donors who were giving money to build a wall at the southern border. The 71-year-old was sentenced to 3 years conditional discharge. That means no jail time and waived his right to appeal. Bannon and several others were charged with defrauding people who gave money for that construction of the southern border wall during President Trump's first term. Prosecutors say he swindled donors who contributed more than $15 million in 2019 as part of a fundraising drive called We Build the Wall.
Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.
Tonight, tech billionaire Elon Musk in the Oval Office defending his role in the new administration as an appeals court just rejected the president and Musk's bid to reinstate that funding freeze. President Trump giving Musk the floor to explain the Doge blueprint and his efforts to overhaul the federal government. The admission from Musk over potential for mistakes as his team claims billions of taxpayer dollars have gone to waste without offering any proof. Also tonight, American teacher Mark Fogel released from Russia after being wrongfully detained. Marine veteran Paul Whelan, who was just freed months ago after spending 6 years in a Russian prison, joins Top Story tonight. His relentless push to get Mark out and what life has been like since his return to the U.S. South Carolina Rep. Nancy Mace unleashing explosive allegations on the House floor, accusing her ex-fiancé and several others of assault and rape. We speak with the Attorney General. She claims deliberately delayed investigation into the allegations. Confronting hate, neo-Nazis demonstrating, holding guns and yelling out racial slurs on the border of a historically black community. How residents were able to drive them out. Growing outrage over video showing a parent aggressively shoving two teenage hockey referees to the ice. The moments leading up to the heated moment and the charges that dad could face. And the winter slam racing towards the East Coast with two more storms right behind it. Whiteout conditions blinding drivers in Kentucky. Freezing rain, crippling power lines. Our nation's capital blanketed in snow. Plus, breaking tonight, the astronaut stuck in space might return back to Earth sooner than expected. We'll explain. Top Story starts right now. And good evening. Tonight we start with the world's richest man side by side with the president, defending his efforts to slash government spending. This as a federal appeals court refuses the Trump administration's request to restore his spending freeze. Tech billionaire Elon Musk, his son X right by his side, taking questions for the first time about Doge and his actions shaking up our nation's institutions. It comes as President Trump orders all agencies to comply with Doge to shrink the federal workforce. Musk claiming without evidence that his team discovered billions of dollars in fraud, while also admitting that he won't always get it right.
Nobody's going to bat 1,000. I mean, we will make mistakes, but we'll act quickly to correct any mistakes.
Democrats have long questioned Musk's potential conflicts of interest. One reporter pressing him on those concerns this evening.
I just have to follow up to the Pentagon contracts. If you have received billions of dollars in contracts from the Pentagon, and the president's directing you to look into the Department of Defense, is that a conflict of interest?
And are going to do at the president's request.
Does that present a conflict of interest for you?
No, because you'd have to look at the individual contract and say, first of all, I'm not the one, filing the contract. It's people at SpaceX or someone who will be putting for the contract.
Take a look at this. Just some of Musk's key businesses, including SpaceX, Tesla, and X, have all come under some sort of investigation, even lawsuits from a number of government agencies. And not all reporters were allowed inside the Oval Office today. The executive editor of the Associated Press, the AP, writing, "Today we were informed by the White House that if AP did not align its editorial standards with President Donald Trump's executive order renaming the Gulf of Mexico as the Gulf of America, AP would be barred from accessing an event in the Oval Office." This afternoon, AP's reporter was blocked from attending an executive order signing. NBC News senior White House correspondent Gabe Gutierrez covering it all tonight from the White House.
Tonight, tech titan Elon Musk with his young son in the Oval Office.
If we don't do something about this deficit, the country's going bankrupt.
Defending his aggressive push to downsize the federal government.
If you have rule of the bureaucrat, or if the bureaucracy is in charge, and then what meaning does democracy actually have?
But the leader of President Trump's Department of Government Efficiency, or DOGE, the wealthiest man in the world whose businesses have massive federal contracts, was also pressed about potential conflicts of interest.
All of our actions are fully public. I fully expect to be scrutinized and get a daily proctology exam, basically. Might as well just camp out there. So it's not like I think I can get away with something.
Following criticism from Musk, the Department of Homeland Security today firing several FEMA workers, accusing them of circumventing leadership by using taxpayer money to pay for New York City hotels for migrants.
The public is saying, why are we paying all this money? This is for years. This has gone on.
But Musk was pressed about what Democrats call a hostile takeover of government.
You couldn't ask for a stronger mandate. The people voted for major government reform, and that's what the people are going to get.
Democrats also argue a constitutional showdown may be brewing as the Trump administration faces mounting legal challenges over its cost-cutting moves.
Public employees who serve this country well. You should be respected, not rejected.
Over the past week, judges have temporarily hit the brakes on President Trump's freezing of some federal spending, which was challenged by several blue states, and offering federal workers buyouts opposed by some unions.
And now a judge who's an activist judge wants to try and stop us from doing this. Why? Why would they want to do that? I campaigned on this. I campaigned on the fact that I said government is corrupt. And it is.
Today, Vice President J.D. Vance in Paris after suggesting judges aren't allowed to control the president's legitimate power, setting up a new battle over presidential authority.
The issue here isn't the courts trying to control the president. It's the president trying to control the law.
I agree wholeheartedly with Vice President J.D. Vance. What DOGE is doing is making sure that your taxpayer dollars, all of us, are spent in the way that they're intended to be spent.
President Trump tonight.
Maybe we have to look at the judges. I think it's a very serious violation.
Saying he'll follow court rulings.
I always abide by the courts, and then I'll have to appeal it.
All right, Gabe Gutierrez joins us from the White House. Let's pick up right there from a snowy evening in D.C. Gabe, he was talking about appealing, and we've just learned that another court has ruled against the Trump administration's federal funding freeze. Walk our viewers through what we know.
Yeah, Tom, it may be an incremental step in this legal saga, but today a federal appeals court rejected the Trump administration's bid to pause a lower court's order that temporarily halted a massive freeze in federal funding. Now, you remember that yesterday that judge in Rhode Island blocked the funding freeze for now. Well, in its ruling today, a 3-judge panel for the First U.S. Circuit Court of Appeals wrote that the defendants do not cite any authority in support of their administrative stay request. So this legal battle will continue, Tom.
Yeah, I know there's a lot of news coming out of the White House tonight. I want you also to get us updated on the Trump administration negotiating the release of American Mark Fogel from Russia. We understand he's on his way to the White House now.
Yeah, Tom, that broke this afternoon. Fogel is flying back tonight on a private plane of Trump's special envoy Steve Witkoff, who led the negotiations for Fogel's release in Moscow. Now, the Pennsylvania native was sentenced to 14 years in prison for possession of cannabis, which his family says was to treat back pain. The U.S. has considered him wrongfully detained. And President Trump said today that the U.S. gave Russia not much in return for Fogel's release. Meanwhile, Fogel's family is saying tonight that they are beyond grateful for his release, Tom.
Yeah, still a lot of questions there, Gabe. We thank you for that. And because of those questions, as Gabe just reported there, Mark Fogel tonight becoming the first prisoner released by Russia during the Trump administration. It comes after several prisoner swaps in recent years with that country. WNBA star Brittany Griner was freed from Russian custody in December of 2022. And just last August, another group was freed, including Wall Street Journal reporter Evan Gershkovich. And Paul Whelan, a U.S. Marine veteran who was detained in 2018 while attending a friend's wedding, he was sentenced to 16 years in a penal colony on espionage charges that the U.S. denied. He was freed after nearly 6 years in captivity. Tonight, Paul Whelan joins Top Story Live in our Spotlight interview. Paul, it is a pleasure to have you here. We thank you for giving us some of your time tonight. Talk to us about what this day is going to be like right now for someone you also fought to get out of a Russian prison.
Yeah, thanks for having me. It'll be a surreal moment for him coming from a third world country back to a first world country. All the, the pleasures, the the things that we take for granted will be at his beck and call. He's going to have food. He'll be, coming back malnourished because the food in these labor camps is really bad. He'll need medical care, dental care, things like that. But he will enjoy being free. I think, with his friends and family, he'll be just, loving life.
Yeah. Can you give us a few more details, right, on what it's like to be detained in Russia? You mentioned even dental care, the food. I mean, what are some of the conditions that Mark has been going through over these past 3 years?
Well, the Russians say that the poor treatment is part of the punishment. The camps are labor camps. They're really bad. Just the facilities are bad. They're old. The one I was in was a prisoner of war camp in World War II. You have cold water. It's very irony. Everything is just in bad condition. And you're putting up with a lot of corruption from the prisoners, from the prison administration, as well as the government. Mark was lucky that he had lived in Russia for 9 years, so he speaks Russian. He understands the culture. But it's difficult, and it's hard when you're there, knowing that other people are being traded and that the U.S. government's doing things and you're being left behind. So a lot of us worked to get him back. And if you remember, about 5 months ago, I stood on the steps of the U.S. Capitol with Congressman Haley Stevens, and we were speaking to some of your journalist colleagues. And I was asked a question about Mark, and I said, we are coming for him. He just needs to be patient. Well, 6 months later, he's coming home. And that's because there's a bipartisan effort on the Hill, as well as people in the NSA and the State Department, to get Americans home, especially when they are wrongfully detained.
You kind of opened the door there, and so I want to ask you about this. Mark was left out of multiple prisoner swaps before his release. You were also left out of 2 exchanges and called it a, quote, serious betrayal at the time. What was it like when people like Brittany Griner got out before you did? And do you hold any resentment that other people got out earlier?
I don't. I fully understand the situation now. Russia was dangling things in front of the Biden administration, and they were taking what they could get. Obviously, the FSB colonel, the assassin, was in Germany, and the Russians kept changing the goalposts, wanting different things. So for me, they wanted the assassin, and that's why they ended up taking Evan also to kind of sweeten that deal. For Trevor Reed and Brittany, they wanted other things. It was disheartening to be left behind. But when Brittany got home, she did a lot to help me. Trevor, the same thing, speaking out on my behalf. I give those two some credit for helping. But it is demoralizing when, especially, the 4 and 5 year mark goes by, you're still sitting in prison and nobody's, seeming to do anything. Luckily for me, Secretary Blinken and Ambassador Carstens from the State Department were doing a lot. They worked with our European allies to put together a huge trade and got Evan, myself, and Alsu Kurmasheva, another reporter, back from Russia.
I interviewed Ambassador Carstens, and he talked to me about the moment that he had to call you when Griner was released. Do you remember that phone call? I'm sure you could never forget it. What do you remember about that? Because that had to be an incredibly tough conversation.
I took the phone from the prison warden. I was in his office. I had 5 FSB officers standing around me. There were a couple prison officers standing around. And I took the phone, and the person on the phone said it was the U.S. Embassy, please hold for the White House. And they transferred the call to the White House, and I spoke, to a person I'd never met, just somebody I knew from phone calls and whatnot. And, I was told that there was bad news, that Brittany was going home and I was staying. And, we had a frank discussion about what that meant and the fact that the U.S. had nothing else to trade with Russia for my release, with Victor Bout going home. So it was an interesting call. I think it was professional on both sides. But, my message was clear to the White House that, it was time for me to come home. And I give them credit. It did take them another 1.5 years, but they did get me home.
Did Russia play mind games with you, saying, oh, you're going to be released, you're not going to be released? I mean, was there some of that at play as well?
Oh, yeah. There was a lot of psychological torture, if you will. They weren't stupid enough to hurt me physically, but every night they would come and wake me up every 2 hours to check to make sure that I hadn't escaped. So, for the last 4 years, I never slept more than 2 hours. And this is something that they do to harass people. But they would tell me that I was going home or I wasn't going home, or they would tell me about things that were happening in the news. The FSB would come to visit. And, although we had, a professional relationship, I could tell that they were trying to get under my skin with, the political situation. I also had means of communication home. We had burner phones and whatnot. So I was speaking to Ambassador Carstens and Secretary Blinken, as well as journalists. And I knew what was happening, to some extent on our end, which really helped. But yeah, psychologically, I feel sorry for Mark, because he's been there for 3.5 years putting up with this nonsense.
And then, Russia has used Americans as bargaining chips over the last decade, right? And now they seem to be running out of high-profile detainees. Should Americans be worried they'll be charged with false crimes if they visit Russia?
Well, if you go to Russia, you may not come back. So my advice to U.S. citizens and the advice of the State Department is don't go to Russia. Stay home. Go to Canada. It's a lot safer. Russia's just not a place for Americans to go. 1986 was the last time before my arrest that the Russians had done this. But now they're doing it, every year. They're grabbing Americans. I think there are 20 Americans in prison in Russia. Some had been living there. Others are tourists. There's Andrei Kachorian. He was going from the U.S. to Armenia to visit family. He was just transiting through the Moscow airport, and the FSB arrested him on a made-up charge. It's ridiculous, but he's there, and he's waiting for help from the U.S. government to come home.
Paul Whelan, we thank you for your time tonight. We thank you for being here on Top Story.
Thank you very much. I appreciate it.
Next tonight, we're going to bring it back here at home in that shocking moment on the floor of the House of Representatives. South Carolina Representative Nancy Mace publicly accusing her ex-fiance and 3 other men of serious crimes, including rape and sexual abuse. Mace also accusing South Carolina's Attorney General of failing to prosecute the men. NBC's Ryan Noble spoke to that AG and has more from the Capitol.
South Carolina Congresswoman Nancy Mace taking to the House floor to publicly accuse 4 men, including her ex-fiancé, of what she described as heinous crimes against women, including herself.
I'm going scorched earth. So let the bridges I burn this evening light our way forward.
Mace, without specific evidence, spent close to an hour detailing allegations, including rape and filming women and young girls without their consent. She accused her ex-fiancé, Patrick Bryant, of being at the center of the scheme, which she says she uncovered on his phone.
I found myself face to face with the darkest corners of humanity.
Bryant, who Mace was engaged to until 2023, vehemently denied her claims. I categorically deny these allegations. I take this matter seriously and will cooperate fully with any necessary legal processes to clear my name. The other men named by Mace in the speech also forcefully denied the allegations and called them untrue. Mace also attacked South Carolina Attorney General Alan Wilson.
There were deliberate delays in an investigation in what I turned over.
Wilson, who could be a future political rival of Mace's in the South Carolina governor's race, said the Congresswoman has her facts wrong.
She's never voiced any concerns about her case. And had she raised any concerns, I would have been completely shocked because I was unaware that she had a case being investigated.
By giving her speech on the House floor, Mace has wide latitude under the Constitution's speech and debate clause, which protects members' comments from lawsuits. But those comments need to be part of legitimate legislative activity. Mace argued the allegations were part of her rationale for introducing bills related to the protection of women. A source with direct knowledge tells NBC News she consulted with a lawyer to make sure the speech was constitutionally protected.
Ryan Nobles joins us tonight from Capitol Hill. So, Ryan, are these men charged with any crimes related to this? And what else did the Attorney General tell you in his interview?
So the answer to that is no, Tom. There have been no charges filed, but we have confirmed with the South Carolina Law Enforcement Division that her ex-fiance is under an active investigation. But they say that investigation is ongoing. And as we pointed out before, no charges have been filed. As for the Attorney General, he was very clear that if there is something that is, if there is merit behind these claims that she is making, and those charges are brought to his office, he will investigate them. But he makes the point that it's not his responsibility to be involved at this stage of an investigation. It would be up to law enforcement to investigate investigate these claims. And then there's a real possibility that if a law enforcement entity finds enough credible evidence to move forward with a charge, that it wouldn't come to the Attorney General, it would come to a local prosecutor.
All right, Ryan Noble's there with a very big interview as well. Ryan, we thank you for that. For more on the explosive allegations by South Carolina Representative Mace, I want to bring in Meg Kennard. She's a national politics reporter for the Associated Press and has covered South Carolina politics extensively. Meg, it's great to see you again here on Top Story. I want to ask you first, I mean, this was so explosive. How is this news from Washington playing out with Mace's constituents in South Carolina?
Hey, it's great to be back with you. I think it's fair to say that there are a lot of South Carolinians right now who either woke up today after learning about what happened overnight or who watched this live and were very surprised by what they heard. Now, Nancy Mace has often spoken, dating back to 2019, about some previous sexual assault that she said she experienced as a teenager. And so she's been kind of open about that part of her life and speaking very personally. So it's not that part that's surprising, but it is seeing that U.S. House floor used in this manner, to see a member of Congress not giving a 1-minute speech, which we're used to seeing, but going on for nearly an hour to talk about personal experiences and also to make these allegations against her ex-fiance and others. That is very surprising. And so for South Carolinians who may be represented currently by Nancy Mace, or who may be those voters that she may be trying to reach out to if she runs for governor, they're kind of getting a new side of learning exactly who she is as a person and seeing her use this place of politics to talk about these personal issues.
Are people asking questions about the men who have been accused and whether they're going to be investigated or not?
I think that there's probably some conversation happening about that, but it's still kind of the shock, really, of seeing all of this unfolding and, you know, kind of wondering where the investigation is maybe going. That comes next.
Yeah, the strange part, if that's even the right word, is that there is talk about Mace possibly running for governor, correct? Somebody she might be running against would be the Attorney General, who we just heard from in Ryan's piece there. She is accusing the Attorney General of really not looking into this. Among the leading candidates right here, the state's Attorney General, Alan Wilson, is currently leading, right, along with the state's current Lieutenant Governor, Pam Evitt. How would this play out in the race, do you think?
Well, let's keep in mind that there's more than a year until actual filing happens in this contest. It doesn't even occur until 2026. So there's a lot of runway left, but you're right that Alan Wilson is a well-known politician in South Carolina, son, obviously, of Congressman Joe Wilson, and in his 4th term currently as state attorney general. So he's well-known. Lieutenant governor, and there are others, some state lawmakers who are potentially thinking about jumping into a GOP primary. So with politics underneath everything that's happening here, that is important context for people who are thinking about how they feel about what Nancy Mace said on the House floor, and then spinning forward to that GOP primary, which will be the first time that South Carolina has had an open primary in the governor's race in quite a long time, since Nikki Haley was first elected back in 2010. So it's going to be a very active race regardless, but at this very early moment, there are already plenty of people interested, including Nancy Mace.
Yeah, Meg Kennard, I'm sure we're going to check in with you as that race develops and as these allegations grow as well. We thank you for being here tonight. We want to turn out to that high-stakes meeting at the White House between President Trump and Jordan's King Abdullah. It happened earlier today, where the president doubles down on his controversial plan for the U.S. to take over Gaza. NBC's Andrea Mitchell has the late details.
Jordan's King Abdullah at the White House after President Trump threatened to cut off aid to Jordan if the king doesn't take in Palestinians from Gaza, which Jordan has opposed. King Abdullah offering instead to take in thousands of sick children from Gaza.
I think one of the things that we can do right away is take 2,000 children that are either cancer children or in very ill state to Jordan as quickly as possible.
That's really a beautiful gesture. That's really good, and we appreciate it.
The president also doubling down on his plan to own Gaza and rebuild it.
We're not going to buy anything. We're going to have it, and we're going to keep it, and we're going to make sure that there's going to be peace, and there's not going to be any problem. I can tell you about real estate. They're going to be in love with it.
King Abdullah saying Egypt will present a plan in response to the president's, who then suggested he won't withhold aid to either country.
I don't have to threaten with money. We contribute a lot of money to Jordan and to Egypt, by the way, a lot, to both. But I don't have to threaten that. I think we're above that.
Meanwhile, President Trump also doubling down on his threat to Hamas after seeing how emaciated 3 Israeli hostages were when they were released last week.
They look like Holocaust survivors.
The president repeated his demand that Hamas not just release a few hostages this week, but all of them by noon Saturday.
They either have them out by Saturday at 12 o'clock or all bets are off.
Israel's Prime Minister Netanyahu has now put his troops on alert along the Gaza border, saying if Hamas doesn't live up to their end of the hostage deal on Saturday, Israel will resume intensive combat operations. Tom?
All right, Andrea, we thank you for that. A lot to discuss here. The refusal of Jordan and Egypt to accept Palestinian refugees is rooted in a complicated history. I want to give you a visual of the region to help you understand a little more. The Gaza Strip, you see it here. It's located on the Mediterranean Sea. It does share a border with Egypt, and the Rafah crossing is the only Gaza border crossing not shared with Israel. Jordan, on the other side, shares a border with the West Bank. Now, Jordan has accepted Palestinian refugees since the 1948 war surrounding the creation of the State of Israel. The country currently holds more than 2 million Palestinian refugees, the most in the world, according to the UN. But since October 7th, both countries, which have peace treaties with Israel, have rejected the idea of accepting more Palestinian refugees, saying they support the creation of a Palestinian state and fear the permanent displacement of Gaza's population could make that impossible. After President Trump's suggestion Jordan and Egypt take in Palestinians, both countries, along with other Arab nations, releasing a joint statement rejecting any plans to move Palestinians, saying doing so would, quote, threaten the region's stability, risk expanding the conflict in the region, and undermine prospects of peace and coexistence among its people. For more on this conflict, NBC News special correspondent and former Tel Aviv bureau chief for NBC News, Martin Fletcher, joins Top Story once again today. Martin, it's great to have you here. This is really complicated, right? And we want our viewers to understand what's happening here because the president is sort of throwing out a lot of ideas, some which may not be reality and others which may. Why, if we can answer this question, why won't Jordan and Egypt take more Palestinian refugees?
Well, that's a great, simple question and with a complicated answer. But the bottom line is that Jordan simply believes it's got too many Palestinian citizens. A large proportion of Jordan is already Palestinian.
Some say 50%.
Yeah,
of Jordan are Palestinians, right?
That's right, a very high number. So if more Palestinians come, the monarchy fears that they will threaten the stability of the country. And for a similar reason in Egypt, they're both for the same reason. They don't want Palestinians from Gaza in their country for the same reason. And they're both also afraid that Islamic militants could join the crowd coming into their country, further destabilizing things.
And President Trump, when he says, things like, and I'm paraphrasing here, that he's going to take over Gaza and they're going to move the Palestinians, I mean, what is the plan there? I mean, is that even possible?
It seems impossible. Look, you've got 2 million Palestinians in Gaza. Where are they going to go? One important point is that actually 100,000 Palestinians from Gaza have already gone to Egypt. They're the ones who could buy their way out. It costs $5,000 for an adult and $2,500 per child. So 100,000 Gazans have already gone to Egypt. They're the ones with money, obviously. The ones left behind are the people who would then need to be somehow persuaded or forced to leave.
What did you think about
President Trump?
Yeah, what did you think about King Abdullah there side by side while President Trump is saying these things?
Well, the offer of accepting 2,000 sick Palestinian children.
Children, right.
Yeah, I thought he was just trying to get on the good side of President Trump, trying to say something positive. And it is something very positive, of course. By the way, sick children can also go from Gaza to Egypt. And they have been going to Israel. So it helps. But I thought it was more of a way to get on the positive side of President Trump rather than anything else.
You've covered the region for decades. We see those images of parts of Gaza that are completely decimated. You see the tents, people now living in tents. What do you think happens there?
Well, it's an extraordinary situation. You've got hundreds of thousands, even 1 million people going north of the line that Israel drew to those towns, which are devastated. So where are they going to live? They're going to be in tents. What are they going to eat? What kind of food will they have? The questions of what they will do is beyond belief. And my question would be, let's ask those people. Has anybody asked them, what do you want? Do you want to leave Gaza? Would you accept to go somewhere else if any country could be persuaded to accept you? Or do you want to stay in that world of destruction? And there's no schools, there's almost no hospitals, there's very little food. The situation the Palestinians will be in Gaza is indescribable and inconceivable. What do they want to do? I would love to know.
But have any of these Arab nations, Muslim nations, Persian nations, Iran, have they offered?
They have not offered, and the opposite. They want them to stay in Gaza for the reason you mentioned earlier, which is that if they leave, does that make it easier for Israel to take over Gaza? Will they be allowed to go back again? According to President Trump and the Israeli government, not so clear they'd ever be allowed to return.
While I have you here, and I know we're running out of time, do you think this ceasefire deal is going to collapse, or do you think the threats are going to force Hamas to release more hostages?
I think that it may well collapse this weekend, even though it's pretty much each side is maneuvering in order to pressure the other side. As you probably remember, my wife has one family member who is still a hostage. So obviously everybody's hoping they'll be returned, but I don't know. It doesn't look very good, does it, right now?
Martin Fletcher, always great to have you here, and we'll be thinking about your relative as well. Still ahead tonight, confronting hate, the standoff in Ohio, white supremacists wielding Nazi flags and yelling out racial slurs confronted by residents, held a historically black community successfully forced them out. Plus, the hockey dad's serious foul on the ice. Look at this. What led to this father violently shoving 2 teen referees onto the ice? And the serious health warning tonight, the cans of tuna you need to hear about being recalled at several popular retailers. We'll explain next. We're back now with a troubling story out of Ohio, where tonight a community is uniting after confronting a group of white supremacists who wave swastika flags on a highway overpass. The confrontation happening on the outskirts of Lincoln Heights, a historically black community. NBC's Antonia Hilton has more, and a warning: this report contains offensive images.
A hateful demonstration unfolding on an overpass in Cincinnati as more than a dozen people gathered, donning all black and waving Nazi flags, weapons, and yelling racial slurs. Community members quickly confronting the group. Traffic camera video showing the moment those demonstrators rush back into a U-Haul truck and leave. Social media video appearing to show the same moment from the perspective of the demonstrators. The crowd that drove them away, burning the swastika flags left behind. Local police responded to the incident on Friday around 2 p.m., but made no arrests, in a statement calling the gathering offensive but legal.
The reason that I made the decision when I first encountered them that I was not making an arrest was because there was no law being violated. They were open carrying in accordance with Ohio's open carry law.
Reverend and community leader Julian Cook demanding answers.
Were you surprised that no arrests were made?
Absolutely. We had questions about why there was no arrest made when there were clear violations of the law. For example, in the state of Ohio, it is illegal to ride as a passenger in the back of a cargo truck. We wanted to make sure, had these individuals been checked for warrants, these signs that were hung on the bridge, that's government property, that's vandalism.
The racist demonstration took place on the border of the historic black community of Lincoln Heights, the first black self-governing town to form above the Mason-Dixon line, America's dividing line between the North and South. To black residents, this location was no coincidence.
It is very clear. There's no way around it. This was an act of violence. We must not push that under the rug. It is not by chance that this happened in this community at this time.
The Jewish Federation of Cincinnati saying in part, "We will not be intimidated. We urge all citizens of Cincinnati to stand with us in rejecting hate and building a community where all people can live without fear or intimidation." Anger boiling over as residents reel from those blatant images and words of hate.
It cannot be legal to stand in the middle of the street and stop my truck and call me that word.
But remain determined. The Reverend and dozens of other community members marching to the overpass to show that hate has no home here.
We wanted to go to that spot to make it clear that we are resolute, that we are not afraid, that hate will not win here, that love will triumph.
Antonia Hilton joins us now. So, Antonia, we heard there in your report, no arrests were made. But what happens to this community? I mean, are they going to have to keep seeing these hateful protests right there in front of their face?
They'll be living with this for some time, Tom. Look, what they've been told by law enforcement is that a full investigation is going to be completed. And what typically happens in these cases is officers are going to have to go out, find people who might have dash cam video, who are driving by, neighbors who have Ring cameras, who saw the U-Haul pass through, for example. That can take some time. They'll have to review all of that and see if any crimes were committed. But of course, part of the challenge here, right, is as days go by, the pain is very much still there. Trust can be lost. And that is what the pastor is worried about right now, Tom.
All right, Antonia Hilton, we thank you for that report. We want to head to Seattle now in the moment that landed one hockey dad in police custody. The father arrested after walking onto the ice and pushing two teenage referees to the ground. NBC's Morgan Chesky has that troubling video and why the dad said he did it.
Tonight, the father you see here facing assault charges for walking onto the ice in the middle of a youth hockey game and shoving 13 and 14-year-old referees to the ground in a violent outburst.
In my 40-plus years of hockey, I've never seen anything as disgusting and repulsive as what this parent did on the ice.
Seattle police say they're also looking at this angle of the incident, which shows the father walking onto the ice while play was stopped. 12-year-old players looking on as he shoves the refs. The crowd gasping as the man walks away, while one ref holds his hip